The aforesaid clauses have been incorporated by on the now the Engineer-in-Chief on 27/1/2023 issued a communication which in paragraph 4 it is stated as under, it is on page 19. Reading of paragraph 4 of the Engineer-in-Chief communication dated 27/1/2023, it is nothing but expanding the scope of 4.7 within bracket 2I cited supra. In other words, incorporating certain words in 4.7 within bracket 2I by the Engineer-in-Chief is without authority of law. Accordingly, the petitioner has made out a prima facie case. Per contra, and counsel for the respondent resisted the aforesaid contention and submitted that it is only nature of clarificatory
and
reminded to the concerned competent engineers to stop. 4.7 within bracket 2I of PMGSY SBD/MBD approved by the cabinet, read with the Engineer-in-Chief communication dated 27/1/2023 within bracket paragraph 4. It is crystal clear that it is nothing but expanding the scope of 4.7 within bracket 2I. The engineer has no authority to clarify 4.7.2, which is nothing but expanding the scope of the aforesaid clause, and he is not the competent authority. Accordingly, the petitioner has made out a prima facie case. Hence, annexure 1 dated 27/1/2023 stands fast.
May I seek liberty?
Petition allowed.
Only this much, Lordship. Lord, any action taken under those provisions of 4.7 and whatever of the SBD and MBD, that should not suffer, Lord.
No, that will not suffer. How?
Let that clarify.
No.
And one more thing, Lord. Bidding process shall not be finalized without leave of the court. This is the order, judicial order, Lord, 411/22 in this case.
That will merges with the final order.
There, Lordship.
Just with the final order.
Can that be made?
It is 27/1/2022.
22. Annexure 1 27. 20.
Much.
Serial number 20 is adjourned for 1 week.
Some liberty, Lord, whatever observation to recall and whatever.
No, that is there always. We have said only Engineer-in-Chief is not the competent authority.
Some liberty to.
Sir, where is the question of liberty? It is always there.
नहीं होगा हजूर, तो ये जितना जो काम नहीं किया है मेंटेनेंस वाला सब रह जाएगा. डेवलपमेंट का बात है, इसलिए हम इतना इंसिस्ट.
There was no necessity to issue such a clarification.
That was competent. Engineer in charge was competent.
47.2, that suffice. Record of poor performance. It does not say which record. You can take any record.
लेकिन सफर कर जाएगा डेवलपमेंट. जो कुछ भी डाल दिया जाए कि इंजीनियर इंचार्ज विल बी कॉम्पिटेंट.
No, we are not the competent. We are not competent authorities.
Serial number 21, Kabir Kumar Singh versus the State of Bihar for the Principal Shri Vijay Kumar.
Your Lordship, wide annexure 3, Your Lordship, all the bidders has been disqualified, Your Lordship, and direction was given to retender the fresh retender, Your Lordship. But subsequently, wide annexure 7, Your Lordship, after 80 days, Your Lordship, they have again review that evaluation committee, your lordship, and whereby the petitioner has been disqualified, your lordship. And
No, what is the work which has been disqualified? Straight away, if you go to the
your lordship, according to 4.4b B1, there is page number, your lordship.
your technical bid has been rejected.
Your lordship, all bidders have been rejected, your lordship. But subsequently, and notice and direction was given to retender the tender, your lordship. But thereafter, after 8 days, your lordship.
Now, where is this 18/8/2022?
Your lordship.
In prayer 1,
18.
18/8/2022.
Your lordship. Annexure 3, your lordship, at page number 36, your lordship.
33,
Your lordship. 36.
36.
I am at serial number 3, your lordship, Amit Kumar Singh.
From here afterwards, try to incorporate annexure number in the prayer so that it will be easy for judges to read.
Your lordship.
Annexure 3.
Your lordship. By this annexure,
Your name is Amit Kumar Singh.
your lordship.
Point.
B1, your lordship.
This is the defect
Your lordship.
according to them. Where is this 4.4
At page number 41, your lordship.
51?
41, page number 41 of the brief, your lordship. But before that, I would like to submit, your lordship, all the 5 bidders have been disqualified, your lordship.
Sir, let us
Your lordship.
relevant clause 4.4b again at B19.
A small b, your lordship, there are.
Read the relevant
Your
portion.
lordship. Each bidder must demonstrate availability for construction work, either owned or on lease or on hire, of the key equipment stated in the appendix to ITB, including equipments required for establishing field laboratory to perform mandatory tests, and those stated in the appendix to ITB.
Where
Has submitted, your lordship, that.
have you demonstrated this in your application?
Your lordship. Paragraph number 13, paragraph number,
No, the application. You have to demonstrate in the application. No.
lordship.
Where is your application? Application for bidding.
Your lordship. Annexure. Annexure 1, your lordship, at page number, sorry, annexure 2, your lordship, at page number 35, your lordship.
No, this is a communication. Where is the application? There is the application form or not?
That is not a online,
Describe the application form.
that was online form, your lordship.
Correct. In the online forum, there must be, you are required to demonstrate that you fulfill this 4.4b, B
Your lordship.
and 1(i).
That has been filled up, your lordship.
Because they are saying that you are not fulfilling this.
That is that, but what happened, all bidders have been disqualified.
Forget about others. You have come up, you have approached this court, you have to satisfy that you fulfill this clause.
1 week time may be granted, your lordship, I will.
Without that, how to entertain the petition? Writ petition itself is not maintainable.
1 week time may be granted, your lordship, I will.
Take down. Short question for consideration is whether petitioner participated in the process was required to comply one of the criteria, namely 4.4 capital B within bracket small b. Each bidder must demonstrate. Next one line. Available small subpara. Availability for construction work, comma, either owned or on lease or on hire, comma, of the key equipment stated in the appendix to ITB, including the equipments required for establishing field laboratory to perform mandatory tests, and those stated in the appendix to TO ITB, capital letter ITB, semicolon. According to the next part, according to the respondent's version that the above clause has not been fulfilled by the petitioner. In the result, his application has been rejected. In bracket technical bid. Perusal of the records, the petitioner has not produced a relevant application form which has been sent through online. In order to know whether is there any column relating to demonstrating the aforementioned clause in the application form itself, or he is required to satisfy the official respondents at a later date. He is permitted to produce the application form submitted online before the next date of hearing. Failing, the writ petition would release this matter after 2 weeks.
Serial number 22 is adjourned for 2 weeks. Serial number 23, versus Siwani Private Limited versus the Union of India College for Dismissed. Shri Kumar Shandu.
Agreement, is there any? Where is the agreement?
Lords, the short case is, Lords, after Lords agreement, Lords, within 8 months, Lords, the contract was to be completed. It was not done, Lords. They have taken ground for Lords.
Is there any arbitration clause?
Yes, Lords, that is there, Lords. And the arbitration clause, Lord, page 103, Lords.
Then he has to invoke this clause.
Lords.
A writ petition is not maintainable.
Lords.
None appears for the petitioner. And counsel for the petitioner is hereby directed to apprise as to how the present writ petition is maintainable in the light of the fact that the agreement, an arbitration clause has been incorporated. This matter next week.
Lordship, appearing on behalf of the bank.
Bank.
Yes.
Status quo, Lords, of bank guarantee encashment, Lords.
Huh?
It is status quo, Lords.
There is order.
Lords, earlier, Lords.
Serial number 24, Mrs. Vijay Kumar Singh versus the State of Bihar for the petitioner Shri Pravas Ranjan.
Item 23.
It is rejected.
My lord, I'm extremely sorry. My lord, I was here in the court.
Next week.
Okay, much over.
Writ is not maintainable. Arbitration, you have to invoke arbitration clause.
My lords, I'll assist my lords on this.
For that purpose only, we have adjourned the matter to next week.
My lords, I am in talks with the railway authorities, my lord.
No, whoever it may be.
My lords.
Arbitration clause is there or not?
My lords, it is there, my lords.
Then we'll decide whether can we ignore arbitration clause and enter
My lord.
arbitration or not.
My lord.
Lordship, this is against the decision of the Technical Bid Evaluation Committee, Annexure 4, page 29, by which my technical bid has been held to be non-responsive for the reason that the validity of the bank guarantee which has been furnished as earnest money is short of 6 months, which was required in terms of the notice inviting tender. Lordship, I would request
shows the relevant clause.
Yes,
Bank
right.
guarantee.
Exactly. My lords, welcome. Annexure 1, page 19 is the notice inviting tender. And the relevant page is page 23, clause 14.
Is clause 14.
14C. Bank guarantee of nationalized/scheduled bank may also be submitted within the state of Bihar. The above instrument shall remain valid for the minimum period of 6 months after last date of receipt of tender.
What is the last date of?
Yes. Annexure 1, page 19, last date of receipt of tender is 17/8/2022.
From that date, 6 months.
Lordship 6. Now I submitted the bank guarantee, Annexure 2, page 25. Now, as per my bank guarantee is valid for till 21st of February 2023, little more than 6 months. 21st February 2023.
No, it has to be taken with effect from last date. 17/8/2022.
So it is for more than 6 months?
17/8/2022.
Yes, and my bank guarantee is
6 months.
6 months. Now they say that it is short of 6 months for the reason that on the last day, on 17/8/2022, for submission of they they issued a query agenda.
Extended.
Yes, and they extended.
Extended on what date?
Yes, they extended it on 17/8/2022.
17/8/2022.
22.
Extended up to what date?
Extended up to 23/8/2022.
23/8/2022.
And now they say that because it is 23/8/2022, so therefore it should have been 22. Absolutely good.
Yes, sir.
Lordship, you find paragraph 14 of the counter.
Lordship, the not counter affidavit date is sufficient. See, bank guarantee he has obtained on 20th August 2022. Correct? That is prior to extension. That suffice. And earlier you have already fixed last date as 17/8/2022. Petitioner has prayed for the following relief. Crux of the matter is whether bank guarantee furnished by the petitioner dated 20th August 2022 and it is valid up to 21/2/2023 is in order or not. Just a perusal of Annexure 1 relating to notice inviting tender issued on 13/7/2022 while assigning the last date of application as a 17/8/2022. Clause 14 of NIT reads as under ABCD on page 23. 14C is relevant to determine whether bank guarantee executed by the bank guarantee furnished by the petitioner 20th August 2022 is valid or not. Full stop. Reading of the last date of submission of application as a 17/8/2022, it is evident that bank guarantee dated 20th August 2022, which is valid up to 21/2/2023, clause C of 14 is fulfilled. Due to administrative difficulties, respondents were stated to have extended the last date of submission of application 23/8/2022. Now, contention of the respondent is that bank guarantee is required to be taken note of with reference to extended date 23/8/2022. The same cannot be accepted for the reasons that last date prescribed is 17/8/2022 and petitioner had obtained bank guarantee on 20th August 2022 and merely last date was extended from 17/8/2022 to 23/8/2022. The petitioner cannot be asked to obtain or get another bank guarantee subsequent to 23/8/2022 for a period of 6 months, when he had already obtained bank guarantee on 20th August 2022. In the light of these facts and circumstances, the petitioner has made out the prima facie case so as to interfere with the impugned order at annexure so and so. Accordingly, it is set aside. Writ petition stands allowed.
First, may make submission. The bank guarantee has been issued on 16th of August 2020.
On 16th of August instead of 20th.
Serial number 25, Chanchla Devi versus the state of Bihar for the petitioner state of Bihar as well.
Kindly pass over for the day.
Pass over.
Serial number 26 is passed over for the day. Serial number 27, Imani Refrigeration and Company versus the state of Bihar for the petitioner Sri Sanjeev Ranjan.
Initially, the writ petition was filed, my lords, for a declaration that in spite of the fact that respondent number 8 bid was not responsive, but on a representation, my lord, even though essential condition was not being met by him, there was correspondence. But subsequently it transpired, my lord, that I have been declared a successful bidder. It relates to, my lord, installation of air condition in 3 civil courts. And my lord's submission is that I have been issued, my lord, I have been declared a successful bidder after, my lord's filing of the present.
What is the reason for withholding of your technical bid?
Well, the writ has become infructuous. He has been declared the winner in financial bid also. He has been asked to execute the agreement for the work, and I have verbal instruction.
That means he has been
He has been given. I am filing that counter affidavit.
My lord, I have been declared successful, but till date agreement, I have deposited all requirements, but till date agreement is not being executed on account of.
that is not your prayer.
Relief. My lord, that is not one of the relief I have sought in the writ. Not some direction, because it is in relation to.
Land Council petitioner has prayed for the following relief.
My lord may take.
Then counsel for the respondent so and submitted that award of contract has been ordered in favor of the petitioner. Therefore, the present petition do not survive for consideration. So, at this stage, land counsel for the petitioner submitted that further process of agreement and other issues like issuance of work order are incomplete. In this regard, the concerned person is hereby directed to take note of and expedite the matter at the earliest. With the above observation, writ petition
In fact, it's the other way around. We have asked him to come for execution of agreement subject to certain formalities. In pursuance to that, he has submitted certain documents which are under verification. Once that verification is done, that agreement would be executed. And to that effect,
at this stage, land counsel for the respondent that there is already process of agreement and it was made known to the petitioner and he is required to undertake certain clauses and fulfill the requisite material information. if it is so, petitioner is hereby directed to take note of material information and proceed with the matter.
My lord, the counter may be taken on record.
Counter affidavit, initially you mentioned counter affidavit filed and the same is taken on record.
But only performance guarantee was required, we have already paid, but much learned friend is.
No, if you want, we will say that simply it has become infructuous. Don't expand the scope of this code.
Serial number 28, Shore Everywhere Infrastructure Private Limited versus the Managing Director, Bihar Medical Services and Infrastructure Corporation Limited for the dismissed over Jubair Rasani.
Conditional terms will change later on.
Condition. Patna. Yes. 28.
27.
Hello, on behalf of the respondent, Bihar Medical
Medical.
Infrastructure Development Corporation. Against the
No, he has not questioned anything. He is asking for a direction for refund of withheld amount of 10%.
against the liquidated damages he is asking. The presented application is not maintainable for the reason he has an alternative remedy.
Arbitration.
Yes, he has not annexed. So this live before the
Give an opportunity. None appears for the petitioner when counsel per the respondent on instruction submitted that the present writ petition is not maintainable in the light of the fact that petitioner has a statutory remedy available to him to stop. In order to give one opportunity, release this matter next week. There is no representation. The contention of the respondent would be taken note of and proceeded to dispose the writ petition.
Now the case adjourned for few cases, serial number 17, Mrs. Vishal Miltech Private Limited versus the State of Bihar for the petitioner Sri Raj Kishore Prasad.
May it please your lordships. This was the case in which your lordships had said that admittedly the amount that was decided to be paid under 10 cc was paid after 4 years. That was an amount of 3 crores 90 and over which, my lords, because of their delay, my lords, I have filed this writ application claiming interest. Then, my lords, your lordships, they admitted that yes, after payment was made. If your lordships would be pleased to see only 2 paragraphs of their counter affidavit, they admit this fact. I would show to your lordships, my lords, there is no denial. Kindly come to me, lords. Page 36 of their counter affidavit. Paragraph 7, that from the chronological sequence of events mentioned above, it is crystal clear that
So
claim.
page 36, counter affidavit on behalf of respondent 1 to 7.
Lordships.
But page 36 is Roman 27. Para 27.
My lord.
Yeah, आपका page
Roman 27.
37. Kindly come to me, lords. 37, para 7. Para 37, my lords. My lords, that from the chronological sequence of events mentioned above, it is crystal clear that the claim of the petitioner to grant benefits of clause 10 cc of the SBD has already been allowed to the petitioner under memo number so and so 30th January 2018 of the writ petition. And it was a claim that was lodged and it was being considered since 2014.
No, have they rejected your claim in any of the para?
They do not say about
My
that.
lord,
No, why you are not entitled to between 2014 to 2018?
No, they do not deny. This is what I am submitting, my lords. They do not deny the
my
fact.
lord, Lecture 15 is the order passed by this honorable court, and pursuant to that order, my lord,
Annexure 15.
my lord, Lecture 15, page 84, my lord, of the writ petition, my lord.
What?
That is the order passed by this honorable court, and pursuant to that order, by the Annexure 6, petitioner was paid.
Yes, by the annexure 16.
And
That was in
and
2018.
thereafter,
No, para 6 is what is that? Land from so and so. That is submission.
Annexure 16 is the decision taken by the government for payment of.
Sir, what is the directions of this court?
The action was to consider the case of the petitioner,
Representation.
my lord.
My lords.
And in representation, he has not claimed the interest, and after receiving the payment,
But,
almost after 1 year, he has raised the claim for the interest, my lord. And in clause 10 CC, there is no provision of interest, my lord. In a special circumstances, his payment was delayed because intervention
Where
of
is the 10 cc?
10 cc, my lords. 10 cc is there. 10cc, if my lord would kindly come to my lord's page 49.
No, why it was adjourned from yesterday?
It was adjourned because the entire SBD agreement was not there. And entire SBD agreement is there.
10cc.
10cc is already there.
Yesterday, my lords want to know whether there is a
Arbitration clause.
in that.
So that clause, my lords, is it in 25 for that, my lord? Could not annex the entire SBD.
But arbitration clause is there.
My lords, admittedly in clause 25,
And approach.
they are very cumbersome.
And that apart, see, you have approached this court in the year 2016 with reference to claim in 2014.
My lords,
There is a lapse on your part also.
no, that the honorable court had remanded the matter. The honorable court said that you go and raise before the, which my.
No, it's all right, but you have filed a writ petition in 2016.
Lords, they had kept it pending earlier since 2012-13. And even from 2014, when they kept on waiting, then I came to this honorable court. And the honorable court asked me to go to the department. I went.
In the agreement, which is the clause for interest,
No, in the agreement, there is no such clause.
then you are not
It
entitled.
has to be decided by, in arbitration, because in arbitration, it cannot be said that I'm not entitled.
Then is there any provision under the Interest Act?
Yes, under the Interest Act, my lords, I'm obliged for this query. Interest Act. Discuss, sir. Discuss. In the Interest Act, it is the, of course, the court can decide it. It is there. Any
Where
court.
is the prayer in the writ petition?
It's 25.
NCC is not relating to interest.
No, 10cc, the issue was,
All right, in your writ petition, have you sought for payment of interest?
my lords, the very prayer, if my lords would be kind enough to come to the prayer portion.
No, in CWJC 17167 of 2016.
16.
The written comment.
Interest. Since they were not deciding whether it will be.
No, it's all right, but when you are making a claim in earlier litigation that you are entitled to so and so amount along with the interest, where is that claim?
Let me make one thing clear. Earlier they were of the view that it would be payable under 10CA. 10CA was confined when it would be a period not exceeding 18 months. Since admittedly the work was for more than 18 months, they had enhanced the period later by 9 months. So admittedly when it went beyond 18 months, so 10cc would be attracted. And for this, whether 10CA would be attracted or 10cc would be attracted, they took the rate for price escalation in 10CA is lesser. Rate for price escalation in 10cc is...
Sir, show us your prayer in CWJC 17167 of 2016.
That was only relating to 10cc, not 10CA. So therefore that question was there. In that, because they had not decided.
Sir, there is no demand by you for payment of interest during the period from 2014 to 2016.
Again, I would submit, since the issue there was whether 10CA or 10cc would be a, that issue they decided subsequently, and therefore that after deciding that 10cc would be applicable, they made the payment in 2018. Now, the quantum of interest, which would be, of course, that can be a matter of adjudication by arbitration or whatever forum it may be lost. But interest, they cannot totally deny. That is my submission.
Sir, cause of action accrued in 2014.
My lords.
You have approached in 2016.
Yes, my lords.
The year 2016 also, you have not demanded the interest.
No, in 2015 also, my lords, when 2016 I came, the Honorable Court was pleased to remand the matter to the authority itself.
Correct, sir. In your request, was there any demand that I am entitled to interest also? Accrued in 2014.
That I'll have my lords. The file. 2016 writ petition is not here.
The year 2016 also, you have not demanded the interest.
No, in 2015 also, my lords, when I, 2016.
It's taken prima facie there is a delay in claiming interest during the intervening period from the year 2014 to 2018. Sublime Council for the petitioner is hereby directed to appraise this court with reference to WJC 17167 of 2016. To the extent whether was there any demand of payment of interest during the or not from the year 2014 to 2018. Sublime Council for the petitioner is hereby directed to appraise this court with reference to WJC 17167 of 2016. To the extent whether was there any demand of payment of interest this next week or not.
अच्छा क्या claim था पहले वो था because the dispute there was whether 10 CA or 10 CC that was continuing.
Then you might not have demanded interest.
Naturally, my lord, since the dispute was there, so if they can only say quantum, whether of course the honorable court in writ will decide.
Sir, your prayer should have been before the authorities. The principal difference of amount along with the interest.
10 CA or 10 CC. That was continuing.
The interest part is, I think, it is missing. And even in if you are not demanded in 2016 litigation, you are not entitled.
Quantum, whether of course previously, my lord, since that was not the issue, so he might not have. That is my apprehension in 2016.
All right, you just verify and.
I'll verify and inform you. Then it will come after 1 week after. Yes,
2 weeks. Earlier brief was not handled by him.
No, 2016 it is not. So he might not have. That is my apprehension in 2016.
All right, you just verify and.
The hearing for hearing serial number 29, Ajay Kumar Mishra versus the Union of India for the appearance to Shobhi Shyam.
Come after 1 week after. Yes.
File supplementary affidavit.
Earlier brief was not handled by him.
No, 2016.
Malo, kindly see your lordship order dated 9 January 2023, order number 11 mile.
The hearing for hearing serial number 29, Ajay Kumar Mishra versus the Union of India for the appearance to Shobhi Shyam.
File supplementary affidavit.
Malo, kindly see your lordship order dated 9 January 2023, order number 11 mile.
File supplementary affidavit.
Malo, kindly see your lordship order dated 9 January 2023, order number 11 mile.
What is the date of dismissal?
On 29th 2000, my lord. At the next hearing, your lordship.
Yes, Mr. Respondent.
Your Lordships, I have asked them, Your Lordships, paragraph 14 and 16, they have given the reply. Your Lordship, their stand is that because it's a disturbed area, and over there he is so brazenly been disobedient, and the way he has gone about it, they cannot permit such behavior in those areas, because it is not only that individual, but it also tells on the security and the discipline of the others.
No, we are not on merits. We are on the legal issues.
Your Lordships, they have considered the matter, Your Lordships, and they are of the view that they will not be able to convert it into compulsory retirement.
Pass on.
Your Lordships. But it also tells on the security and the discipline of the others.
No, we are not on merits. We are on the legal issues.
Your Lordships, they have considered the matter, Your Lordships, and they are of the view that they will not be able to convert it into compulsory retirement. They will not be able to convert it into compulsory retirement.
Take note. Assistant LPA, appellant. He was a constable.
My lord. Appointed on 1/4/90, my lord.
Take note. He has assailed the order of the single judge LPA, appellant 20 passed in seat 18705
My
of
lord.
2008.
Appointed on 1/4/90, my lord.
He has assailed the order of the single judge LPA, appellant. Three facts of the case are that passed in seat 18705 apparent constable was appointed the year 1990. He was placed under suspension. He has assailed the order of the single judge three facts the year 1999, and it was revoked on 3/11/1999. He was charge sheeted in a departmental inquiry on 24/11/1999 on the alleged charge that he was under intoxication the year 1999 and misbehaved on 3/11/1999. Where is the charge memo?
My lord, the direction 4 for lordship.
He was charge sheeted in a departmental inquiry on 24/11/1999 on the alleged charge that he was under intoxication the year 1999 and misbehaved on 3/11. Where is the charge memo?
My lord, the direction 4 for lordship.
He was charge sheeted in a departmental inquiry on
It is start from page 33, my lord. And
the alleged charge that he was under intoxication.
page 39 is the proposed document and name of oral witnesses, page 40, my lord. It is start from page 33, my lord.
Charges are as under
And
on page 2 of the impugned order of the single judge.
page 39 is the proposed document and name of oral witnesses, page 40, my lord. It is start from page 33, my lord.
Charges are as under on page appellant had furnished his reply to the charge memo on 16/12/1999
Proposed document and name of oral witness.
and it was not satisfied by the disciplinary authority. Thus, the disciplinary authority proceeded to hold inquiry while appointing inquiring officer. Appellant had furnished his reply to the on 7/1999. The inquiring officer submitted his report on 7/3/2000 while holding that the charges leveled against the appellant were proved. Disciplinary authority proceeded to consequently, the disciplinary authority proceeded to issue second show cause notice along with the inquiring officer's report. The inquiring officer submitted his report on 7/3/2000 while holding. You are not submitted your reply to the second show cause?
I have submitted, my lord.
Then you are not mentioned in the dates and event. On what date you are submitted? Consequently, the disciplinary authority proceeded to issue second show cause notice along with the inquiring officer's report. The inquiring officer submitted his report on 7/3/2000. You are not submitted your reply to the second show cause?
I have submitted, my lord.
Then you are not mentioned in the dates and events. On what date you are submitted? Consequently, the disciplinary authority proceeded to issue second show cause notice along with the inquiring officer's report.
21/4/2000, my lord.
21.
4/2000. Page 87, Mr. Lord.
21/4/2000.
My lord.
How can it be? The dismissal order is 29/3. Where is the penalty order dismissal?
My lord.
Page 70.
My lord.
21.
4-14. Page 87, Mr. Lord.
21, 4, 2000.
My lord.
How can it be? The dismissal order is 29.3. 70 onward. Any reference? Where is the penalty order dismissal?
My lord.
Page 70.
My lord.
21.
Page 87, Mr. Lord.
Now, where is the dismissal order? How can it be? The dismissal order is 29.3. 70 onward.
That is Annexure 7, Mr. Lord.
76.
My lord.
So where is the reference to this cost notice and your reply? So where is the dismissal order?
That is Annexure 7, Mr. Lord.
76.
My lord.
Where is the reference to this cost notice and your reply? So where is the dismissal order?
That is Annexure 7, Mr. Lord.
There is no appeal.
Appeal was filed, my lord. Appeal was
The
dismissed.
appellate authority order.
Well, that is the appellate authority order, Section 9, my lord, dated 2/8/2001.
Huh?
Appellate order, my lord, 2/8/2001.
Correct. Where?
My lord.
And I get?
Page 101, my lord.
There is no appeal.
Appeal was filed, my lord. Appeal was
The
dismissed.
appellate authority order.
Well, that is the appellate authority order, Section 9, my lord, dated 2/8/2001.
Huh?
Appellate order, my lord, 2/8/2001.
Correct. Where?
My lord.
And I get?
Page 101, my lord.
There is no appeal.
Appeal was filed, my lord.
The appellate authority order or revision?
The appellate authority order, my lord, 101.
Revision order.
That is revision order, that is Annexure 11, my lord, 20th March 2013, my lord.
Page?
That is page 230, my lord.
30.
My lord.
The appellate authority order or revision?
The appellate authority order, my lord, 101.
Revision order.
That is revision order, that is Annexure 11, my lord, 20th March 2013, my lord. That is page 230, my lord. My lord.
The appellate authority order or revision?
The appellate authority order, my lord.
Revision order.
That is revision order, that is Annexure 11, my lord, 20th March 2013, my lord. That is page 230, my lord. My lord.
CRPF rules.
Sir.
CRPF rules.
Sir.
The punishment rules.
That is Annexure 11, proceeding order is stated. Annexure 11, under Section 11(1), my lord.
11(1).
My lord. Minor, which speaks for the minor punishment, my lord.
There is no rule.
My lord, that is rule, my lord. The CRPF 1995, my lord.
In that rule, sir, which is the relevant provision for imposition of penalty of dismissal from service?
That is, my lord, Annex 11 proceeding on the stated. And 11, my lord, 12 of the act itself says, my lord, punishment for dismissal, my lord. 12, my lord, can you see?
There is no rule.
My lord, that is rule, my lord. The CRPF 1995, my lord.
In that rule, sir, which is the relevant provision for imposition of penalty of dismissal from service?
That is, my lord, Annex 11 proceeding on the stated. And 11, my lord, 12 of the act itself says, my lord, punishment for
Section 12 is
dismissal, my lord.
not section 12.
My lord.
Place of imprisonment and liability to dismissal.
My lord, that is only. My lord, can you see section 10, my lord? Less heinous offense, my lord. You will also find section 11 minor punishment, and section 12 you will also find place of imprisonment and liability for dismissal of the imprisonment, my lord. 11, my lord, 12 of the act itself says, my lord, punishment for
Section 12 is not section 12.
my lord.
Place of imprisonment and liability to dismissal.
My lord, that is only. My lord, can you see section 10, my lord? Less heinous offense, my lord. You will also find section 11 minor punishment, and section 12 you will also find place of imprisonment and liability for
Which
dismissal of the
section he has
imprisonment, my lord.
invoked while dismissing you from service?
My lord, dismissal was passed under section 11, my lord. 11, my lord. 11, 1.
11 is for minor penalty.
That was the taken ground was in the appellate before the High Court Patna also, my lord. In the, you will also find the writ application itself, my lord. This point was taken.
Which section he has invoked while dismissing you from service?
My lord, dismissal was passed under section 11. Para 6, you will also find the MP in order, my lord.
11 is for minor penalty.
That was the taken ground was in the appellate before the High Court Patna also. Para 6, 7, 8, you will also find. Let us sing it. I also quoted section 9, 10, 11 also, my lord.
Which section he has invoked while dismissing you from service?
My lord, dismissal was passed under section Para 6, you will also find the MP in order, my lord. That was the taken ground was in the appellate before the High Court Patna also. Para 6, 7, 8, you will also find. Let us sing it. I also
Section 10 is relating to imprisonment.
Para 6, you will also find the MP in order, my lord.
Section
Your Lordship, Rule 27, Chapter 6, Rule 27 may be seen. Procedure for award of punishments. The punishment shown as item 1 to 11 in column 2 of the table below may be inflicted on non-gazetted officers and men of the various ranks shown in each of the headings of column 3 to 6 by the authorities named below, such as procedure for award of punishment. The punishment one is dismissal from dismissal or removal from the force to be inflicted after formal departmental inquiry.
Where are reading?
Then 27, Your Lordship.
27?
Rule 27 of the Central Reserve Police Force Rules 1955.
The schedule is there.
Yes. Dismissal or removal from the force.
No, on receipt of inquiring officer's report, disciplinary authority is required to invoke which provision of Rule 27?
Rule 27 of the Central Reserve Rule 27 provides for the punishment of dismissal or removal from service. And 2 is reduction to a lower time scale.
Correct, but procedure?
Procedure, it says, to be inflicted after formal departmental inquiry.
Authority is required to invoke which
And that procedure, Your Lordship.
No, on receipt of inquiring officer's report, what are the powers and functions of the disciplinary authority?
Dismissal or removal from service. And 2 is reduction to a lower time scale.
Correct, but procedure?
Procedure, it says, to be inflicted after formal departmental inquiry.
Authority is required to invoke which
And that procedure, Your Lordship.
No, on receipt of inquiring officer's report, what are the powers and
28 is
functions of the
appeal.
disciplinary authority? Correct, but procedure?
Procedure, it says, to be inflicted after formal departmental inquiry. That procedure, Your Lordship.
No, on receipt of inquiring officer's report, what are the powers
28
and
is
functions of the
appeal.
disciplinary authority? What is the last sentence?
Authority issue second so cause.
Submitted his
C provides the.
yes, C.
Your Lordship. The procedure for conducting
1, 2, 3, 4, 5.
5 and 6, Your Lordship may see.
What is the last sentence? Yeah, notice. Submitted is a reply on the inquiring officer's report and show cause notice. Submitted thereafter disciplinary authority proceeded to impose the penalty of dismissal from service on 21/4/2000.
5 and 6, Your Lordship may see.
Being agreed and dissatisfied with the order of penalty of dismissal, preferred appeal before the appellate authority, appeal and revision. In both, he has suffered order on 2/8/2001 and 20th March 2000. Hence, on 21/4/2000, filed writ number so and dissatisfied with the order of penalty. Also, he has suffered an order preferred appeal before the appellate authority. In the result, the present LP revision. In both, he has suffered order. Next, Parliament Council for the petitioner submitted that 20th March 2000. Hence, on 21/4/2000, filed writ number so and dissatisfied with the order of penalty. Also, he has suffered an order preferred appeal before the appellate authority. In the result, the present LP revision. In both, he has suffered order. Has not been cited as a witness. Submitted that 20th March 2000. Support of the medical certificate and has not been cited as a witness. Also, he has suffered an order. In the doctor further submitted that disciplinary not been cited as a witness. The disciplinary authority support of the has not certificate considered a reply by the petitioner as a witness against a second show cause notice and inquiring officer's report. Further submitted at 21/4/2000 before imposition of penalty of dismissal from service. The disciplinary authority further submitted that considered a reply by the petitioner charge of absence curfew hours and show cause notice and inquiring officer's report. Further submitted at 21/4/2000 before imposition of penalty of dismissal from service. The disciplinary authority further submitted that considered a reply by the petitioner charge of absence curfew hours and show cause notice and inquiring officer's report and failed to obey orders of his superior 11/1992 to 16/11/1999 as he had and failed to obey orders of his gone outside the premises of CRPF 11/1992 to 16/11/1999 as he had used gist of the abuse against superiors at the premises of CRPF using a particular unparliamentary language against MK Sinha, the then Deputy Commandant DCO 11th Battalion, Maharani, is not forthcoming. Abuse against superiors at the premises of CRPF using a particular unparliamentary. Therefore, the alleged allegation is allegations are very vague. DCO 11th Battalion, Maharani, these issues have not been apprised by the disciplinary, appellate, alleged and learned single judge. Allegations are very vague. Have not considered. These issues have not been apprised by the. It is also submitted that disciplinary, non-examination of a doctor and learned single judge. Allegations are very non-citing the doctor as a witness and non-examination and cross-examination of a prime witness would vitiate entire proceedings. Non-citing the therefore order of the learned single judge and earlier orders of disciplinary, appellate and revision of a prime witness authorities were required to be set aside. So, per control and counsel for the respondent resisted the aforesaid contentions and submitted that, having regard to the alleged charge levelled against the appellant and the fact that he is in a disciplined force and revision of a prime witness, alleged charges which were in a departmental inquiry suffice to hold that, having regard to the alleged charge, no infirmity, the order of the disciplinary, appellate, revisional and order of the learned single judge. Mere non-examination of a doctor suffice to hold that does not vitiate inquiry proceedings. The order of the disciplinary, the third, the learned counsels for the respective parties, revisional and order of the learned single judge. The appellant joined service as a constable in the year 1990. Non-examination of he had committed alleged does not vitiate inquiry proceedings. His deeds while he was in service for the respective parties. In the year 1999, suspension. Joined service as a constable in the year 1999. Thereafter, it was revoked. He had committed to stop. He was subjected to disciplinary proceedings. His deeds while he was.
And also, my lord, land confinement of 15 days, my lord.
Huh?
And also land confinement. 15 days I were confined, my lord, for period. Line confinement. Double punishment. 2/11/19 to 16/11/19, my lord. I was illegally confined.
He was subjected to
So double punishment has been given.
That was confinement to the.
That is a different aspect.
Also, my lord,
And even while confined, he ran away. That
No,
was
and
also
also
an
land
aspect.
confinement. 15 days I was confined.
He is so disciplined
No,
that
that is a different aspect. That confinement is under section the
2/11/19 to
Act,
16/11/19,
whereas the punishment of dismissal is under rules.
So double punishment has been given.
that was confinement to the.
That is a different aspect.
And even while confined, he ran away.
The inquiry concluded in imposition of penalty of dismissal from service. He has exhausted the remedy of appeal and revision Act, whereas the and also before the land judge.
Double punishment has been given.
That was confinement to the that is a different aspect. And even while confined,
The inquiry concluded in imposition of penalty of dismissal from service. Doctor's certificate has been taken note of remedy of appeal and revision in support of alleged charge and also of intoxication. In the absence of citing the doctor and examination and cross-examination, doctor's certificate has been taken insofar as intoxication in support of alleged charge is not of intoxication proved in the manner known to the law. In the absence of citing the doctors and examination, the other charges are doctor's certificate has been relating to as far as intoxication, misbehaved, abuse, not intoxication, and using unparliamentary language against one M.K. Sinha proved in the manner known to the law. In the absence of disobeying the orders of the other charges are relating to as intoxication, misbehaved, abuse, and using unparliamentary charges are very vague against one MK and it is not supported by material disobeying the orders of information while framing the article of charges charges are very vague. In other words, charge must contains ingredients, material disobeying the orders of like dates and events. Perusal of charge number 2 and 3 charges. Ingredients are not forthcoming. Charges are very vague. In other words, charge must contain further ingredients. We notice that disciplinary authority, like imposing penalty of dismissal from service on 9/3/2000, has failed to consider reply of the appellant, as is evident from the dismissal order. Further, we notice that disciplinary authority, like imposing penalty of dismissal from service on 9/3/2000, has failed to consider reply of the in para 6 of the dismissal order from the dismissal order. The disciplinary authority stated as on page 75 read to the writ petition. Therefore, issuance of second show cause notice along with the inquiring officer's report and proceeding in imposition of penalty. The disciplinary authority stated as an only an empty formality. In other words, the very object of providing second show cause notice along with the inquiring officer's report and in non-consideration of petition appellant's reply and proceeding in imposition of is defeated to the extent that disciplinary authority has not considered an empty formality respective contentions urged in his reply to the second show cause notice along with the inquiring officer's report dated on 21/4/2000 and proceeding in imposition of is defeated to the extent even perusal of the disciplinary authority has not considered appellate and revisional authority respective contentions. They have not urged in his considered the relevant second show cause notice along with the inquiring officer's report contentions urged by the on appellant. Stop. Next paragraph. Even perusal of the appellate non-citing they have not author of the document vitiate the inquiry in the light of Apex Court decision, the case of UCO Bank versus SC Giriotra 1995, 3 supplementary or something is that. So and so. Insofar as non-examination author of the document Appreciate the inquiry of FS court decision, relevant witness, UCO Bank versus SC Giriotra, 1995. 3 supplementary or something is that. Apex court decision in the case of Root Negi assist the petitioner appellant's case. Non-examination author of the document. Question next paragraph. Even though learned single judge has referred to certain decisions. Apex court decision in the case of Root Negi assist the petitioner appellant's case. Question next paragraph. Even though and also extracted single judge has referred to certain decisions. Rule 27 within brackets small c of CRPF rules 1955. However, it is to be noted that also extracted has referred to certain non-citing a relevant witness, non-examination of small c of CRPF rules appreciate the inquiry. This has not been appreciated further. However, it is to be noted that also extracted non-citing charges are not relevant witness specific non-examination has not been taken note of. Appreciate the inquiry. In the light of these facts and circumstances, the appellant has made out a prima facie case so as to interfere with the order of disciplinary, appellate, revisional, and order of the learned single judge. All the orders are set aside. In the light of these facts and while allowing the writ CWJC 18705 of 2008, appellate, accordingly LPA stands up and order of the learned single judge. All the orders are set aside. In the light of these facts while allowing the writ CWJC.
Serial number 30, Zain Razan versus Division of India for the Dispersed Tribunal.
Accordingly, LPA stands up.
The punishment order is annexure 30 at page 76. The punishment is Milor's the 5% cut in pension Milor's for 2 years.
5% or 10%?
5%.
What is the date of?
Date of punishment Milor's 25/1/2012. The punishment order is annexure 30 at page 76. The punishment is Milor's the 5% cut in pension Milor's.
No,
sorry. Recommendation
8 to
2013.
What is the date of?
Date of punishment Milor's 25.
No, you have mixed up the issue. While giving list of dates, why are you referring to the 10% cut pension?
That was the recommendation of the state government, Milor's, which has been rejected by the Ministry of Home Affairs, Milor's.
No, you have mixed up the issue. While giving list of dates, why are you referring to the 10%? What is the date of issuance of second shock of notice?
Milor's. 15/11/2011, Milor's.
15/11?
2011. Annexure 6 at page 40, Milor's.
No, you have mixed up the issue. This who is for the respondent? While giving list of dates, why are you referring to the
Milor's,
what is the date of
some crucial
second shock of notice?
technical issues may permitted to place, Milor's.
No, before that we'll ask some one question. Yes, for the respondent. Union of India. You are representing the disciplinary authority.
My lord, some crucial
Yes, madam.
technical issues.
Huh?
Union of India.
To place
That-
No, sir, I don't know whether Union of India is disciplinary authority. Who is disciplinary authority? Yes. Who has imposed the penalty of 13 pension? Union of India.
It is the disciplinary authority which has passed the order of punishment, that is the Union of India.
Under Secretary, Union of India. Then can't you open your mouth and say, now before imposition of penalty on 8/2/2013, whether petitioner was provided copy of the UPSC advice?
Yes, madam, it was provided.
No, it should be obtained on what point of time?
Case before the punishment order.
No, sir. Along with the second show cause, have you sought his explanation on the UPSC advice?
Yes, madam.
Whether petitioner was provided copy of. What is the date of advice?
Yes, madam, it was provided.
No, it should be obtained on what point of time?
Case before the punishment order.
No, sir. Along with the second show cause,
Annexure 12 is the
on the UPSC advice.
has been sent to the Under Secretary Home Bihar. And in this minute, the court's order is also being quoted. And therefore, the Nath Ram has submitted his reply on 5.
Where is his reply on 5/1/2013?
13.
Where is that?
Yes, at
Annexure
page,
12.
page
Annexure
73 to
12.
page 75. Has
12.
been sent to
Annexure
the
12 at page 73.
Page 75. And in this minute, the court's order is also being quoted.
75 is
73, Nath Ram has submitted his reply on 5.
Where is his reply on 5/1/2013?
13.
Where is that?
Yes, at page 73 to page 75. Has
12.
been sent to
Annexure
the
12 at page 73.
Page 75. And in this minute, the court's order is also being quoted.
75 is
73.
Where is the charge number 4?
The charge number.
You have taken 6 long years. Where is the charge number to complete the inquiry?
That in the inquiry report, page number 54, it is recorded, Ballot. There is, with regard to 4 charges, charge number 4 has been pramanic, it is proved.
Correct. What is the charge? Where is that? Charge number 4.
Not communicating to the higher
taken
officer
6 long
with regard
years
to the reports asked
Complete the
for.
inquiry. Page number where?
Yes, that in the inquiry
What is the page number?
Page number 54. It is page number 52, ma'am. There is, with regard to 4 of the inquiry report, charge number 4 has been pramanic, it is proved.
Correct. What is the charge? Where is that? Charge number 4.
Not communicating to the higher officer with regard to the reports asked for.
Page number where? What is the page number?
Charge number 4 is, my lords, the
It is very vague. What is that? On what date he has issued? So and so direction. On how he. Where is the article of charge?
my lord, the annexure. Annexure 1, my lord. That was the, my lord, that was the proposed article of charges, my lord.
Statement of imputation.
There is no imputation mentioned in the charge sheet, my lord.
So direction. On 18.
Yes.
Where is the article of charge?
My lord, the
The
annexure.
statement of imputation.
No.
Attached to the memo of charge.
Correct. Where is the statement of imputation? Because charge is very vague. Read the charge. Whether on what date he has committed what, on what date superior officer gave direction to him. 18. Is there any statement of imputation or not? Then the initiation of inquiry itself is wrong. Correct. Where is the statement? All India Service Rules of Charge.
824.
Read the charge. Whether on what date he has committed what, on what date superior officer gave direction to him. 18. Is there any statement of imputation or not? Then the initiation of
Page
inquiry.
207.
No, which rule is Smoke for the purpose of initiation of inquiry.
Milords 8, Rule 8.
10.
8 Milords, the initiation,
Or
the
8.
8 Milords. At page 207 in my book. Page 207,
No, which rule is smoke for the
subclause
purpose
4
initiation
of
inquiry?
Rule 8. Rule 8.
10.
8 Milords, the initiation, the
Or 8.
8
There is no compliance to 2.
8 2 Milords, yes. At page 207 in my book.
What do you say, Union of India?
But the charge number 4 has been proved.
Correct, sir. It must be supported by statement of imputation. You have All India Service Rule Book 2.
Yes, sir.
Take page, take sub-rule 4 of Rule 8. What do you say, Union of India?
But the charge number 4 has been proved.
Correct, sir. It must be supported by
Such
statement
point
of
has been
imputation.
pointed out by the Departmental Inquiry Commissioner also, Milords, at page annexure 3, Milords.
Take page, take sub-rule 4 of Rule 8. What do you say, Union of India?
Annexure 1 पर है, annexure 1. Annexure 1, page 70. Such point has been pointed out by the Departmental Inquiry Commissioner also, Milords, at page annexure 3, Milords. There is no imputation.
And charge memo is consisting of list of witnesses?
No.
All India Service.
Yes, sir.
Even Milords, on basis of explanation and the charge memo, Milords, sent to the ADG Darbhanga, Milords, and sought comment. And he, Milords, specifically denied no charge was found to be proved against this person, Milords.
Charge was issued by state of
State of Bihar.
They don't look into the read and frame the charges.
Basis of explanation and the charge memo, Milords, sent to the ADG
Yeah,
Darbhanga,
state.
Milords, and sought comment. And he, Milords,
State.
specifically
State
denied
is silent.
no charge was found to be proved
Huh?
against this person.
Created issues and keeping silent. State of
State of Bihar. Annexure 3 at page 29, Milords, the comment was sent by the
the
ADG.
rules were issued in the year 1969.
Sent to the ADG
Yeah,
Darbhanga, and sought comment.
Your undersecretary will not look into the rules before framing charges. Created issues and keeping silent. You don't have time to look into the rules.
Annexure 3 at page 29, Milords, the comment was sent by
Or
the ADG.
easy depending upon some clerk to frame charges. I will just put my signature. Your undersecretary will not look into the rules before framing charges. Created issues and keeping silent. Yes, sir, we will allow. You don't have time on legal issue. Rules.
Annexure 3 at page 29, Milords, the comment was sent by
Or easy depending upon some clerk to frame charges. I will just put my signature. Your undersecretary will not look into the rules before framing charges. Yes, sir, we will allow. You don't have time on legal issue. CAT has not taken note of. Or easy depending upon some clerk. This issue.
Milords.
You have invoked a remedy under section 19 of the Administrative Tribunal Act.
Yes, Milords.
Where is that CAT order?
The order, Milord, at annexure 14 at page 78.
CAT has not taken note of this issue.
Milords.
You have invoked a remedy under section 19 of the Administrative Tribunal Act.
Yes, Milords.
Where is that CAT
Para
order?
6, they take note of.
Para 6 of CAT.
They have taken note of, but they have said that since you have not,
Oh, they have taken note of what? Still in not furnishing,
the appellant has only challenged the punishment order.
but not charge sheet, but not the charge sheet, though he has taken some technical grounds against the issuance of charge sheet, as the applicant was granted proper opposition.
They have taken note of, but
Take
they
down.
have said that since you have not,
They have taken note of what? Still in not furnishing the instant petitioner,
only challenged
filed the order of the CAT, but not the stated Sagar passed in OA 635 of 2013 as the applicant has granted proper opportunity. In bracket annexure 14. They have taken out of not furnishing the instant petitioner filed the order of the CAT. Stated Sagar passed in OA 635.
As on that day, what was it? Annexure 1.
In bracket annexure 14. Instant petitioner filed the order of the CAT.
He was then citizen of police, Samastipur.
The petitioner, while working as the superintendent of police, Samastipur district, he had alleged to have committed certain misdeeds. The petitioner, and he was subjected to disciplinary proceedings in framing article of charges on 20th May 2006 by the state of Bihar. He had alleged to have, he had submitted his reply to the charge memo. The petitioner, and he was thereafter disciplinary proceedings in framing. It was not satisfied by the on 20th disciplinary authority that state of Bihar, and proceeded to hold the inquiry. During pendency of the inquiry, he has attained age of superannuation and retired from service on 31/10/2010. Thereafter, it was not satisfied by the. Consequently, inquiring officer hold the inquiry held that charge number 4 was proved and other charges were not proved. From service on 31. In this regard, show cause notice along with the inquiring officer's report was made available to the petitioner on 15/11/2011. Inquiring officer, he had submitted a reply on 29/11/2011 and other charges were not proved. Having regard to the fact that he has attained age of superannuation and retired from service, and he was in All India Service Cadre. Therefore, he had submitted. File was forwarded to the on 29/11/2011 central government for taking further steps in the matter. Attained age of superannuation and retired from service, and state government is stated to have recommended for imposition of punishment for imposition of penalty of 10% cut in pension on 25/1/2012. For taking further steps in the matter. Age of superannuation and retired from service. And on 24/5/2012, state government is central government recommended for imposition of punishment rejected the recommendation of the state government penalty of 10% cut in pension for the reasons that 25/1/2012 there were no pecuniary loss to the government nor misconduct was committed. For imposition of punishment rejected the recommendation of the state government penalty of 10% cut in pension for the reasons that 25/1/2012. However, there were no pecuniary loss. Central government took a decision government to forward the papers to committed UPSC. For the reasons that however, based on pecuniary loss, reproposal and took a decision by the state government to stop. UPSC recommended for imposition of a 5% cut pension. A copy of the UPSC advice was made available to the petitioner for his say by the CAY to stop. Accordingly, Petitioner had submitted his reply on 5/1/2013. Recommended for imposition of the result 5% cut pension penalty of 5% cut in pension imposed by the copy of the UPSC advice Union of India on 8/2/2013 to stop agreed and dissatisfied with the imposition of penalty of 5% cut in pension 5/1/2013. Petitioner filed penalty of 5% original application before the Central Administrative for the CAT Union of India on to stop CAT rejected the original application 635 of 2013 on 26 August 2016. Hence the present petitioner. Next one, and counsel for the petitioner submitted that from the inception original application before this there is the lacuna for the CAT framing of article of charge to stop CAT rejected the article of charges were not supported by statement of imputation. Hence the present submitted that reading of article of charges submitted that does not constitute charge lacuna for the CAT framing of in other words dates and events are not forthcoming. Article of charges were not supported by statement of imputation. Therefore, charges are very vague. Reading of article of charges statement of imputation and list of documents and list of witnesses were not made available. In other words, along with the charge memo, dates and events are not forthcoming. In terms of Rule 8, sub Rule 4 of Rule 8, very vague of reading of article of All India statement of imputation service and list of documents and list of witnesses were not made available. Disciplinary and appeal rules 1969. The charge memo. See the correct title. In terms of Rule 8, sub Rule 4 of Rule 8, very vague of. So next one, it is further submitted that even though CAT in its order has taken note of disciplinary and appeal that there were technical grounds. However, CAT failed to interfere. So next one, it is further submitted that even though, as is evident from para 6 in its order has taken note of, therefore that there were the impugned order grounds. However, of punishment and order of the CAT are liable to be set aside. Per control and counsel for the respondents as is evident from state, UPSC and Union of India resisted the aforesaid contentions. However, punishment and order of the CAT are liable to be set aside. They have supported the order of the CAT respondents as is evident from state, UPSC and Union of India. They heard the learned counsels for the respective parties aforesaid contentions. For use of the records, it is evident that article of charges issued under sub rule issued under Rule 8 of Rules 1969. They heard the learned counsels for the respective parties is not in consonance with sub Rule 4 of Rule 8, like furnishing a statement of imputation in support of the alleged charge. Rules 1969. The charges, charge number 4, which has not been not in consonance with reproduced here under Rule 8, like subpara, furnishing a statement of imputation in support of reading of the above charge number 4. It does not constitute the charges. Charge number 4 charge for the reasons that no information is available here under, like dates and events on what date the concerned officer superior to the petitioner charge number had given any direction and on how he has disobeyed, etc. For the reasons that in the absence of ingredients constituting charge available, one cannot draw inference that on what date charge concerned framed superior to the charge number 4 had given any direction and is on how he has disobeyed crystal clear charge in the absence of twist. Moreover, constituting charge, it is not supported by one cannot statement of imputation, list of documents and framed list of witnesses. Charge number 4. In order to prove that petitioner had disobeyed a particular direction or orders of a superior. Moreover, with reference to a particular date, statement of and list of documents and list of witnesses. This is a serious lacuna committed by the state of Bihar while framing the article of charges on 20th May 2000. A particular direction or a list of this lacuna has not been taken note of by the a particular date and state of Bihar, this is a Union of India committed by the state of Bihar while framing the article of charges on and UPSC. Even though CAT has taken note of, however, it has brushed aside the union of technical grounds raised by the petitioner framing the article of charges on and UPSC. Even though CAT has taken note of, however, not framing article of charges in the light of Rule 8 of 1969, technical grounds raised by the petitioner. If you go to the root of the matter and UPSC. Moreover, even though in the present case, punishment of cut in pension to the extent of 5% has been awarded only with reference to charge number 4, which is stated to have been proved. If you go to the root of the matter, charge number 4 itself is very vague, as is evident from the cited charge supra to the extent of 5% has been awarded only with reference to charge number 4. Further, it is to be noticed that state has taken 6 long years. Charge number 4 itself is very vague, as is evident from to complete the process of a departmental inquiry initiated against the petitioner. Further, it is to be noticed that next paragraph. In the light of these facts and circumstances, the petitioner has made out a prima facie case so as to interfere with the penalty of cut in 5% pension order dated 8/2/2013 and order of the CAT dated 26/8/2016 passed in OA number 35 of 2013. Next paragraph. In the light of and they are set aside. Writ petition stands allowed. Made out a prima facie case so as to interfere with the
My lords, other consequential benefits like other consequential benefits, my lords.
concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
My lords,
That is not the issue. You go and make an application.
consequential benefits like other consequential benefits, my lords.
Concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
My lords,
That is not the issue. You go and make an application.
consequential benefits like other consequential benefits, my lords.
Concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
My lords,
That is not the issue. You go and make an application.
consequential benefits like other consequential benefits, my lords.
Concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
Milords,
That is not the issue. You go and make an application.
consequential benefits like other consequential benefits, Milords.
Concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
Milords,
That is not the issue. You go and make an application.
consequential benefits like other consequential benefits, Milords.
Concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
Milords,
That is not the issue. You go and make an application.
consequential benefits like other consequential benefits, Milords.
Concerned respondent is hereby directed to settle the monetary benefits of the petitioner within a period of 3 months from the date of receipt of this order.
Promotional benefits also.
There is a question of promotion.
Milords,
That is not the issue. You go and make an application.
खुशियां देते रहें। फकर मुझे होता है पापा आपकी रहमत पे, लोग मुझे जब बेटी आपकी कहते हैं।
अब कई लोग दावा कर रहे हैं कि हनीप्रीत और बाबा राम रहीम फिर से डेरा सजाने जा रहे हैं और डेरा सच्चा सौदा में दोनों की वापसी हो चुकी है। हमने भी ये वीडियो देखा तो इस वीडियो के पीछे का सच क्या है ये जानने के लिए इसका वायरल टेस्ट करने का फैसला किया।
पापा जी हमेशा हमें अपनी शिक्षाओं पर चलने की प्रेरणा और ऐसे ही खुशियां देते रहें। फकर मुझे होता है पापा आपकी रहमत पे, लोग मुझे जब बेटी आपकी कहते हैं।
सबसे पहले वीडियो में आप देख सकते हैं हनीप्रीत और बाबा राम रहीम एक दूसरे का हाथ पकड़े हुए हैं और केक काट रहे हैं। राम रहीम ने हनीप्रीत को केक खिलाया और सिर पर हाथ रखकर आशीर्वाद भी दिया। हम आपको बता दें कि रहीम ने हनीप्रीत को रूहानी दीदी नाम दिया था। हनीप्रीत डेरा चीफ राम रहीम की मुख्य शिष्या होने के साथ साथ उनकी धर्म वीडियो में आप देख सकते हैं। इतना ही नहीं, राम रहीम ने अपने परिवार पहचान पत्र यानी PPP में हनीप्रीत को अपनी मुख्य शिष्या घोषित किया। इस दस्तावेज पर उनके परिवार के किसी सदस्य का नाम नहीं है। हनीप्रीत डेरा सच्चा सौदा प्रबंधन की चेयरपर्सन और वाइस पैटर्न भी हैं। राम रहीम के बाद हनीप्रीत डेरा सच्चा सौदा की गद्दी की असली वारिस मानी जा रही है। ऐसा इसलिए क्योंकि डेरे की यही परंपरा रही है। असल में डेरे में गद्दी नशीं का जो मुख्य शिष्य होता है उसे ही गद्दी सौंपी जाती है। इस वक्त राम रहीम डेरे की गद्दी पर है और उनकी मुख्य शिष्या हनीप्रीत है।
जिंदगी न होती इतनी खूबसूरत।
लेकिन हम ये पता लगाना चाहते थे कि क्या राम रहीम और हनीप्रीत का ये वायरल वीडियो डेरा सच्चा सौदा का है। हमने पूरा वीडियो देखा। इसमें हनीप्रीत कहती हैं कि उन्होंने ये जश्न इंस्टाग्राम अकाउंट पर 10 लाख फॉलोअर्स होने की खुशी में मनाया है। वहीं शेयर किए गए वीडियो में हनीप्रीत ने अपने इंस्टाग्राम फैंस को शुक्रिया कहा।
Thank you, my 1 million Insta fam. आप सब मुझे अपना ऐसे ही प्यार और सपोर्ट देते रहे।
हमने हनीप्रीत के इंस्टाग्राम पेज को भी देखा। उस पर भी हमें हनीप्रीत के 1 मिलियन फॉलोअर्स देखे। हमने इस वीडियो की पड़ताल की तो पता चला कि ये वीडियो यूपी में बागपत के बरनावा डेरे का है। राम रहीम इन दिनों 40 दिनों के पैरोल पर है और वहाँ सत्संग भी कर रहा है, जबकि राम रहीम का सिरसा वाला डेरा सच्चा सौदा बंद पड़ा है क्योंकि राम रहीम को डेरा प्रबंधक की हत्या और 2 साध्वियों के साथ रेप के मामले में 20 साल की सजा सुनाई गई थी और राम रहीम रोहतक की सुनारिया जेल में सजा काट रहा है। हम आपको बता दें कि राम रहीम को अगस्त 2017 में 20 साल की सजा सुनाई गई थी। रेप के 2 मामलों में 10-10 साल की सजा हुई थी। इसके साथ ही 15-15 लाख रुपए का जुर्माना भी लगाया गया था। राम रहीम को उसकी करतूतों के चलते उम्र कैद से भी बड़ी सजा मिली। राम रहीम 40 दिन के पैरोल पर रोहतक की सुनारिया जेल से बाहर आया, लेकिन बड़ी बात है कि ये महज 56 दिन में राम रहीम को दूसरी जमानत मिली है और पिछले 1 साल में राम रहीम को 133 दिन की रिहाई मिल चुकी है। और उत्तर प्रदेश के बरनावा आश्रम में 40 दिन का पैरोल काट रहे राम रहीम ने अपना चौथा गाना लॉन्च कर दिया है। इस दौरान उसने पहली बार भगवा रंग की जैकेट पहनी, साथ ही सिर पर टोपी और टी-शर्ट भी भगवा रंग की पहने नजर आ रहा है। इस तरह खुद का इंसा धर्म चलाने वाला राम रहीम अब पूरी तरह भगवा रंग में रंग चुका है। राम रहीम ने इसी डेरे में तलवार से केक भी काटा था। लिहाजा हनीप्रीत ने इंस्टाग्राम पर फॉलोअर्स बढ़ने की खुशी में केक भी यूपी के बरनामा आश्रम में ही काटा है।
इतनी खूबसूरत, अगर पापा आप ना मिलते। पापा जी हमेशा हमें।
इस तरह हमारी पड़ताल में यह साबित हो गया कि हनीप्रीत का ताजा वायरल वीडियो डेरा सच्चा सौदा का नहीं है।
फकर मुझे होता है पापा आपकी रहमत पे।
इस हफ्ते के टॉप 5 वायरल वीडियोस दिखाएंगे एक छोटे से ब्रेक के बाद। बने रहें, देखते रहें आज तक।
अगर पापा आप ना मिलते। पापा जी हमेशा
ये एमसीडी की सत्ता की जोरदार लड़ाई। किरदार है बीजेपी और आम आदमी पार्टी। जंग 3 दिन से जारी है। मेयर और डिप्टी मेयर से शुरू हुई लड़ाई में शुक्रवार का दिन स्टैंडिंग कमेटी मेंबर्स के चुनाव का था। पहले दिन का हाल देखिए। और ये दूसरे दिन की मारकाट, जब नेताओं को बचने के लिए टेबल के नीचे छिपना पड़ा था। जब शर्मसार हो गया एमसीडी सदर, बोतलें फेंकी गईं, पोडियम तोड़ दिए गए। तीसरे दिन स्टैंडिंग कमेटी के 6 सदस्यों के चुनाव की बारी आई तो एक बार फिर एमसीडी सदन जंग का मैदान बन गया। और पवन सहरावत के रूप में बीजेपी ने आम आदमी पार्टी को बड़ी मात दे दी। आपके पार्षद सहरावत बीजेपी में आ गए और इसके बाद बीजेपी उनको लेकर बड़े जोश और खरोश के साथ सदन में आई। सहरावत ने वोट भी दे दिए। उनको पीएम मोदी की विचारधारा पसंद आ गई। बीजेपी के प्रदेश अध्यक्ष भी आपका एक पार्षद तोड़कर काफी खुश दिखे।
चुनाव होने के बाद
आपके पार्षद
हमारे से
बीजेपी में आ गए और इसके
पूरा दबाव बना रहा
लेकर बड़े जोश और खरोश के साथ सदन
कि आप पूरा
सहरावत ने
चाहे हाउस की बात हो पूरा हल्ला मचा के रखो
पसंद आ गई। बीजेपी के प्रदेश अध्यक्ष भी
ताकि अभी चुनाव नहीं हो
काफी खुश दिखे।
और मेयर तो हमारा ही बनना है, आप पूरा ऐसे हल्ला करते रहो। आम आदमी पार्टी पूरा दबाव बना रहा, अच्छे विचारधारा की पार्टी नहीं है और हमने हाउस की बात इसीलिए पूरा हल्ला आम आदमी पार्टी को छोड़ दिया।
मेरा मानना यह है कि वहाँ जैसा पवन ने खुद कहा कि वहाँ कई लोगों का दम घुट रहा है, जिनका दम घुट रहा है, अगर वो आके खुली हवा में सांस लेना चाहते तो उनका स्वागत है।
लेकिन क्या इसे ऑपरेशन लोटस जिस तरह से आम आदमी पार्टी ने आरोप लगाया था तो उस तरह से आरोप फिर लगेंगे आगे?
उनका काम है आम आदमी पार्टी का आरोप लगाना, उनकी दुकान है। पवन आपके सामने थे, आप पूछ लेते वो अपनी इच्छा से आए।
सिविक सेंटर में इस बार जैसा सियासी ड्रामा हुआ वैसा हाल कुछ सालों में एमसीडी में नहीं हुआ था। मेयर चुनाव में हार का सामना करने वाली बीजेपी ने आखिरी मोर्चे तक आपको खूब छकाया।
पार्टी ने आरोप लगाया था तो उस तरह से
फालतू बात या बकवास नहीं करेंगे बर्दाश्त।
सिविक सेंटर में
खड़ी हो जाएगी घाट जब चित्रा लगाएगी वाट। वाट लगाती चित्रा त्रिपाठी, सिर्फ आज तक डिजिटल पर।
और अब आपको दिखाते हैं इस हफ्ते के टॉप 5 वायरल वीडियोस जो सोशल मीडिया पर छाए हुए हैं। कैसे डीयू में झूमे जो पठान गाने पर पूरा कॉलेज झूम उठा, तो मौत के कुएं में बुलेट वाले स्टंट का वीडियो भी खूब वायरल है। क्या कभी आपने कोबरा के फन वाले जूते देखे? ये वीडियो भी एकदम नया है। मुंबई लोकल में एक महिला ने अपने गाने से कैसे लोगों का दिल जीत लिया, ये वीडियो भी जबरदस्त वायरल है।
बॉलीवुड के बादशाह शाहरुख खान की मूवी पठान ने कमाई के सारे रिकॉर्ड तोड़ दिए हैं। सोशल मीडिया पर झूमे जो पठान गाने पर फैंस ने ताबड़तोड़ रील्स बनाकर पोस्ट किया है। इस कड़ी में अब दिल्ली विश्वविद्यालय की महिला प्रोफेसर्स का एक वीडियो सोशल मीडिया पर खूब देखा जा रहा है, जिसमें वो स्टूडेंट्स के साथ फुल जोश में डांस करती नजर आ रही हैं। ये वीडियो डिपार्टमेंट ऑफ कॉमर्स जेएमसी के इंस्टाग्राम पेज पर 12 फरवरी को पोस्ट किया गया था। ये शानदार दृश्य दिल्ली विश्वविद्यालय की जीसस मैरी कॉलेज, जहां एक कार्यक्रम के दौरान कूलेस्ट प्रोफेसर्स ने बच्चों के साथ शाहरुख खान के पठान के धांसू गाने झूमे जो पठान पर शानदार डांस किया। भारतीय मेलों की शान है मौत का कुआं, जिसे देखने के लिए पब्लिक पैसे देती है। इतना ही नहीं, कुछ दर्शक स्टंटमैन का कौशल देखने के लिए हवा में एक 10 का नोट लहराते हैं और इंतजार करते हैं कि खतरों का खिलाड़ी गोल गोल घूमते हुए उस नोट को उनके हाथ से लेकर चला जाए। सोशल मीडिया पर ऐसे ही एक स्टंटबाज का वीडियो वायरल हो रहा है, जिसने मौत के कुएं में इस अंदाज में बुलेट बाइक भगाई कि वीडियो इंटरनेट पर छा गया। इस वीडियो को 1 करोड़ के आसपास व्यूज मिल चुके हैं। नोट को उनके हाथ से लेकर चला जाए। सोशल मीडिया पर ऐसे ही एक स्टंटबाज का वीडियो वायरल। शौक हो तो फिर कुछ नहीं कर सकते। जी हाँ, सोशल मीडिया पर एक वीडियो वायरल है जिसमें एक शख्स के जूते की स्टाइल सांप के फन के जैसी है। आप तस्वीरें देखेंगे तो देखते रह जाएंगे। जूते के आगे जो नुकीला हिस्सा होता है, वहां पर सांप जैसी आकृति बनती दिखती है और 1 फीट से शायद थोड़ा ही कम होगा, वो फन जैसा दिखाई देता है। बच्चे ही नहीं बड़े भी अचानक देख लेंगे तो शायद डर जाएंगे। सोशल मीडिया पर एक वीडियो सोशल मीडिया पर यह वीडियो खूब वायरल हो रहा है, जिसमें एक सांप और एक कुत्ते की भयंकर लड़ाई हो रही है। और एक चीज से शायद बच्चे ही नहीं बड़े देख लेंगे तो शायद डर जाएंगे। हालांकि अंत में डॉग सांप को मौत के घाट उतार देता है। इस पूरी फाइट को एक शख्स ने कैमरे में कैद किया है, जिसका वीडियो इंटरनेट पर बार बार देखा जा रहा है। इस वीडियो पर 5 लाख से ज्यादा व्यूज मिल चुके हैं। मुंबई लोकल में एक बेहद ही खूबसूरत वीडियो सामने आया है। ये एक महिला का वीडियो है जो सोशल मीडिया पर तेजी से वायरल हो रही है। ये महिला कैंसर सर्वाइवर है और वो अपने अस्तित्व के लिए ट्रेन में गाने गाती है और अन्य कैंसर रोगियों की भी मदद करती है। उनकी आवाज बेहद खूबसूरत है। वायरल टेस्ट टीम, आज तक।
इसके साथ ही वायरल टेस्ट में अभी के लिए इतना ही। मुझे आशुतोष चतुर्वेदी को दीजिए आप इजाजत। बने रहे, देखते रहे आज तक। बहुत नमस्कार।
हो रही है ये महिला कैंसर सर्वाइवर है और वो अपने अस्तित्व के लिए ट्रेन में गाने गाती है और अन्य कैंसर रोगियों की मदद करती है। उनकी आवाज बेहद खूबसूरत है।
मैं जैसे आपको बताया था, मेरी 16 फिल्में 17 फिल्में नहीं चल रही थी। हर आदमी, हमारे देश के कई लोग यहाँ वहाँ जाते हैं काम करने। कोई दुबई चला गया, कोई ऑस्ट्रेलिया चला जाता है, कोई न्यूजीलैंड। ये तो नहीं कह सकते नहीं गए, सभी गए हुए हैं बाहर। मैंने भी सोचा भाई मेरी फिल्में नहीं चल रही तो आदमी को काम तो करना पड़ेगा। मैं काम करने, मेरा एक दोस्त था जो कनाडा में रहता था, उसने बोला यहाँ के। मैंने अप्लाई किया, ये मिल गया, फिर मैंने वहाँ काम करना शुरू किया। मेरी बस 2 फिल्में रह गई थी रिलीज पे। वो इत्तेफाक की बात है सुधीर जी, वो चल कह सकते नहीं गए। वो दोनों फिल्में अच्छी सुपरहिट चली गई। मैंने भी सोचा भाई मेरी अब मैं रुक गया, आदमी को काम तो करना। फिर मेरे दोस्त ने बोला तूने नहीं चल रही है, वापस जा कर काम। फिर उसके बाद 2-4 और फिल्में मिल गई। फिर उसके बाद और फिर और चलता गया और काम चलता गया। अब फिर वो मैं भूल गया कि मेरे पास पासपोर्ट था। पासपोर्ट है वो इत्तेफाक की बात है था। ये मैंने नहीं कभी सोचा कि मैं इसको पासपोर्ट को चेंज करूं। लेकिन हाँ, अभी मैंने अप्लाई किया हुआ है। पासपोर्ट मैं चेंज करवा रहा हूँ। जैसे ही मेरे को वो री अनाउंस कनाडा से आ जाएगा।
सीधी बात, शनिवार रात 9 बजे सिर्फ आज तक पर।
ये मैंने नहीं कभी सोचा। किया हुआ है। पासपोर्ट में चेंज कर रहा हूँ। जैसे कनाडा से आ
एक साल से रूस और यूक्रेन जंग की आग में झुलस रहे हैं। न जाने कितने आशियाने उजड़ गए, कितने सपने खाक हो गए। किसी ने अपनों को खोया, किसी के लिए ये जंग ऐसा नासूर बन गई। जमीन के एक हिस्से में अगर आग बरस रही है, तबाही और बर्बादी से इंसानियत पनाह मांग रही है, तो जाहिर है इसका असर पूरी दुनिया पर पड़ना लाजिम है। बेशक ये जंग रूस और यूक्रेन के बीच चल रही हो, मगर सबसे ज्यादा सवाल अमेरिका को लेकर उठे। तभी अमेरिकी राष्ट्रपति जो बाइडेन की ये तस्वीर सामने आई। अमेरिकी राष्ट्रपति जो बाइडेन अचानक कीव पहुंच गए तो सारी दुनिया चौंक गई। अमेरिका रूस के खिलाफ यूक्रेन का समर्थन करने वाले प्रमुख देशों में
Ukraine was weak and the West was divided. As you know, Mr. President, I said to you in the beginning, he's counting on us not sticking together. He was counting on the inability to keep NATO united. He was counting on us not to be able to bring in others on the side of Ukraine. He thought he could outlast us. I don't think he's thinking that right now. God knows what he's thinking. I don't think he's thinking that.
यूक्रेनी राष्ट्रपति जेलेंस्की ने कहा कि वो अंतिम सांस तक रूस से लड़ेंगे, लेकिन सरेंडर नहीं करेंगे। रूसी राष्ट्रपति व्लादिमीर पुतिन लगातार अमेरिका को निशाने पर लेकर इस जंग के लिए कसूरवार ठहराने का कोई भी मौका हाथ से जाने नहीं देते। तभी तो उन्होंने कुछ ऐसी गिनती सामने रख दी जिसने दुनिया को सोचने पर मजबूर कर दिया। रूसी राष्ट्रपति पुतिन का इल्जाम है कि पूरी दुनिया को सबसे ज्यादा 39% हथियार अमेरिका एक्सपोर्ट करता है, जबकि इस सूची में 19% की हिस्सेदारी के साथ रूस दूसरे नंबर पर है और तीसरे स्थान पर 11% के साथ फ्रांस। तभी तो उन्होंने कुछ ऐसी गिनती सामने रखी जिसने दुनिया को सोचने पर मजबूर कर दिया। अमेरिका कभी नहीं चाहेगा कि रूस और यूक्रेन के बीच चल रहा ये युद्ध समाप्त हो, क्योंकि ये युद्ध अमेरिका को लाखों करोड़ रुपए कमाकर दे रहा है। वर्ष 2020 से अब तक अमेरिका पूरी दुनिया को 38 लाख करोड़ रुपए के हथियार बेच चुका है, जबकि यूक्रेन युद्ध पर उसने 5 लाख करोड़ रुपए ही खर्च किए। इस बीच अमेरिका के लगातार यूक्रेन के पीछे खड़े होने और रूस को ललकारने का एक नतीजा ये सामने आया कि रूसी राष्ट्रपति ने अमेरिका के साथ जारी अपनी परमाणु हथियारों का समझौता निलंबित कर दिया। ये बात दुनिया के लिए बहुत बड़ी है, मगर अमेरिका यही दिखाने की कोशिश में है कि इससे उसे कोई फर्क नहीं पड़ता। इस बीच अमेरिका के लगातार यूक्रेन के पीछे खड़े होने और रूस को ललकारने का एक नतीजा ये सामने आया कि रूसी राष्ट्रपति ने अमेरिका के साथ जारी अपने परमाणु हथियारों का समझौता निलंबित कर दिया। ये बात दुनिया के लिए बहुत बड़ी है, मगर अमेरिका ये दिखाने की कोशिश में है कि इससे उसे कोई फर्क नहीं पड़ता।
So sorry.
रूस यूक्रेन जंग को 1 साल पूरे हो गए हैं। इस लड़ाई में जहां यूक्रेन करीब करीब तबाह हो चुका है, वहीं रूस को भी बड़ा नुकसान हुआ। यूक्रेन के जहां 1 लाख से ज्यादा सैनिक मारे जा चुके हैं, वहीं रूस के भी हजारों सैनिक हताहत हुए हैं। साथ ही इस जंग की वजह से 30 लाख से ज्यादा लोग स्थापित हुए हैं। पिछले साल 24 फरवरी को रूस ने यूक्रेन पर धावा बोला था और ये जंग अभी भी जारी है। रूस यूक्रेन जंग को 1 साल रूस जहां यूक्रेन पर हर हाल में कब्जा चाहता है, वहीं यूक्रेन की फौज अपने देश को बचाने के लिए पूरी ताकत से लड़ रही है। इस जंग की वजह से न सिर्फ यूक्रेन और रूस पर असर पड़ा है, बल्कि ईंधन और खाने पीने की चीजें महंगी होने से दुनिया भर के देश भी परेशान हैं। संयुक्त राष्ट्र महासचिव गुतेरेस ने जंग तुरंत खत्म करने और यूक्रेन में शांति की अपील की।
The one-year mark of Russia's invasion of Ukraine stands as a grim milestone for the people of Ukraine and for the international community. That invasion is an affront to our collective conscience. It is a violation of the United Nations Charter and international law. It is having dramatic humanitarian and human rights consequences, and the impact is being felt far beyond Ukraine.
रूस यूक्रेन जंग के 1 साल पूरा होने पर संयुक्त राष्ट्र महासभा में रूस के खिलाफ प्रस्ताव भी पास हुआ। इस प्रस्ताव में यूक्रेन से रूसी सैनिकों को वापस बुलाने और जंग खत्म करने की मांग की गई। 193 सदस्यीय महासभा में प्रस्ताव के पक्ष में जहां 141 मत पड़े, वहीं विरोध में महज 7 वोट पड़े, जबकि भारत, चीन समेत 32 सदस्य देश वोटिंग के दौरान गैर हाजिर रहे। न्यूज एजेंसी रॉयटर्स के मुताबिक रूस के खिलाफ यूएन आम सभा में पास हुआ प्रस्ताव गैर बाध्यकारी है। ऐसे में इस प्रस्ताव से रूस पर कोई खास असर नहीं होगा। आज तक ब्यूरो। भारत, चीन समेत 32 सदस्य देश वोटिंग के दौरान गैर हाजिर रहे। न्यूज एजेंसी रॉयटर्स के मुताबिक रूस के खिलाफ यूएन आम सभा में पास हुआ प्रस्ताव गैर बाध्यकारी है। ऐसे में इस प्रस्ताव से रूस पर कोई खास असर नहीं होगा। आज तक ब्यूरो।
क्या आप अपना मीडिया प्लान बनाना चाहते हैं स्मार्ट? तो चुनिए नए चैनल आज तक लाइव टीवी को अपने कनेक्टेड डिवाइसेस पर। पहुंचिए इंटरनेट से जुड़े करीब 100 मिलियन स्मार्ट व्यूअर्स तक। एडवर्टाइज करने के लिए ईमेल कीजिए sales@aajtak.com।
तोल मोल के बोल, फिर बात बनेगी। पिछली जुबान तो जनता पूछेगी। क्या बोल गए नेताजी? देखिए सिर्फ आज तक डिजिटल पर। सोशल मीडिया पर लिखिए #क्या बोल गए नेताजी और देखिए हमारा ये शो।
एडवर्टाइज करने के
तोल मोल के बोल, फिर बात बनेगी। पिछली जुबान तो जनता पूछेगी। क्या बोल गए नेताजी?
कांग्रेस महाधिवेशन में सोनिया गांधी का सरकार पर हमला का संवैधानिक मूल्यों पर की जा रही है चोट। खड़गे ने कहा नफरत से देश का माहौल बिगड़ा। गृहमंत्री अमित शाह का नीतीश कुमार पर प्रहार। वाल्मीकि नगर में बोले बिहार में आधा जंगल राज। पूर्णिया में महागठबंधन की महारैली, मंच पर नीतीश तेजस्वी। प्रयागराज हत्याकांड पर गरमाई सियासत। सीएम योगी बोले इस माफिया को मिट्टी में मिला देंगे। अखिलेश ने कानून व्यवस्था पर उठाया सवाल। सिर्फ 44 सेकंड में बीएसपी के पूर्व विधायक राजू पाल हत्याकांड के गवाह और गनर की हत्या। अतीक की पत्नी, 2 बेटों पर एफआईआर। डिप्टी सीएम बोले बख्शे नहीं जाएंगे दोषी। और आज से एक नए अंदाज और नए तेवर में देखिए सीधी बात। रात 9 बजे अक्षय कुमार के साथ सुधीर चौधरी की बेबाक बात। कहा भारत मेरे लिए सब कुछ, छोड़ूंगा कनाडा की नागरिकता। अपनी 2 बेटों पर एफआईआर, डिप्टी सीएम बोले बख्शे नहीं जाएंगे। नमस्कार, बहुत स्वागत है आप सभी का। दोपहर के 2 बज रहे हैं, देख रहे हैं आप आज तक और इस वक्त मैं आपके साथ आशुतोष चतुर्वेदी। और सबसे पहले बड़ी खबर, प्रयागराज हत्याकांड में नया सीसीटीवी वीडियो सामने आया है। अब तक कुल 5 वीडियो सामने आ चुके हैं जिसमें पूरा हत्याकांड कैद है। देखिए, सिर्फ 44 सेकंड में 18 साल पुराने राजूपाल हत्याकांड के गवाह को गोलियों से भून दिया गया, बमबाजी हुई और इस मामले में अब तक 14 लोग हिरासत में लिए गए हैं जिनसे पूछताछ चल रही है, जिनमें बाहुबली अतीक के 2 बेटों और पत्नी भी शामिल है। इसके अलावा टोटल अगर संख्या कह ले तो 14 लोग हैं। और ये जो फुटेज आपको दिखा रहे हैं सीसीटीवी, देखिए इसी कार से उमेश पाल नीचे उतरते हैं और गोलियों से भून दिया जाता है। एक नया सीसीटीवी फुटेज भी सामने आ गया, ये देखिए जरा, इसमें सब कुछ क्लियर है। देखिए, ताबड़तोड़ गोलियां बरसाई गई, बमबाजी भी हुई, धुएं का गुब्बार देख सकते हैं आप। किस तरह से आरोपी अपराधी भागते हैं खुद को बचाने के लिए। जो लोग कार में बैठे थे, गनर भी गलियों की तरफ भागते हैं। ये देखिए, बम फेंका गया, देखिए उमेश पाल नीचे उतरते हैं और गोलियों से भून दिया जाता है। एक नया सीसीटीवी फुटेज भी सामने आ गया, ये अंधाधुंध ताबड़तोड़ फायरिंग, कार को चारों तरफ से घेर के पूरी प्लानिंग के तहत एक साजिशन, एक फुल प्रूफ प्लान तैयार किया गया। कई आरोपी अपराधी इसमें नजर आ रहे हैं और जब ये कार क्रेटा नीचे रुकती है, इससे 2 लोग नीचे उतरते हैं और वहां पर मौजूद शख्स इन पर गोलियों की बौछार कर देते हैं। और ये एक ताजा और जो ये फुटेज आ चुका है 5वां, ये देखिए जरा, अंधाधुंध ताबड़तोड़ फायरिंग। किसी दुकान में ये सीसीटीवी लगा हुआ है और वहां से सब कुछ एक कैमरे में कैद। दहशत का माहौल हो जाता है, दुकानदारों में भी अफरा तफरी का माहौल, ये उठ के खड़े हो जाते हैं। देखिए, और जब ये फुटेज देखिए, नीचे रुकती है, इससे 2 लोग नीचे उतरते हैं और वकील नीचे उतरे, वो पूरे अपने जो एडवोकेट पहनते हैं काला कोट, और वो उसमें नजर आ रहे हैं। और गनर देखिए बेहोश होकर नीचे गिर गया क्योंकि गोली लगी, सीधा गोलियों से भून दिया गया। एक दूसरा जो कांस्टेबल है वो जख्मी हालत में। ये देखिए कैसे बमबाजी हो रही है, बम भी फेंका गया, ये बैग से निकालकर बम फेंका गया और चारों तरफ इलाके में ये धुआं और अफरा तफरी का माहौल। इससे पहले कुछ लोग समझ पाते कि हो क्या रहा है, गोलियों की तड़तड़ाहट से ये इलाका पूरा धुआं धुआं हो जाता है और गूंज जाता है। 18 साल पुराना ये मामला, 3 तस्वीरें अब आपके सामने रख रहे हैं। पहला वीडियो देखिए किस तरह से ये क्रेटा कार नजर आ रही है। एक दूसरा वीडियो, दुकान से जो ये सब कुछ कैद हुआ, गोली चल रही है और दुकानदार नीचे शटर गिराता है खुद को बचाने के लिए, अंदर कुछ लोग हैं। तीसरा वीडियो भी सामने आया सड़क के इस तरफ से, ये देखिए कार रुकी हुई है और किस तरह से फायरिंग। तो प्रयागराज मर्डर केस में नया सीसीटीवी फुटेज सामने आया और देखिए कांस्टेबल उतरता है और बंदूक चलाने की कोशिश करता है, लेकिन तब तक उसको गोली मार दी जाती है। गोली चल रही है और दुकानदार संतोष शर्मा ज्यादा जानकारी के साथ हमारे सहयोगी जुड़ चुके हैं, हमारे संवाददाता संतोष। एक के बाद एक कई वीडियो सामने आ रहे हैं और सब में एकदम बिल्कुल क्लियर अपराधी आरोपी नजर आ रहे हैं, गोलियां चलाते हुए, गोलियां बरसाते हुए और बमबाजी करते हुए। संतोष, नया सीसीटीवी फुटेज सामने आया और देखिए कांस्टेबल उतरता है और बंदूक।
देखिए, बिल्कुल ये जो तस्वीरें आ रही हैं ये दिखा रही हैं कि किस तरीके से रैकी की गई, किस तरीके से बेखौफ होकर के बमबाजी की गई, फायरिंग की गई। जो एक तस्वीर जो सीसीटीवी हम दर्शकों को दिखा रहे हैं उसमें साफ तौर पर दिखाई पड़ रहा है कि एक आदमी अपने झोले में से, सफेद शर्ट का जो व्यक्ति है वो अपने झोले में से बम ऐसे फेंक रहा है जैसे टमाटर फेंक रहा हो, वो घूम घूम कर बमबाजी कर रहा है। तो दूसरा जो शूटर है वो पहले वकील को गोली मारता है, उसके गनर को गोली मारता है और करीब ये कहा जा रहा है कि इसमें अभी तक 9 शूटरों के शामिल होने की उम्मीद है। तस्वीरों में भले ही सीसीटीवी जो अभी तक पुलिस के पास है उसमें 5 शूटर कैद हुए हैं, लेकिन पुलिस को अंदेशा है कि 4 शूटर और हो सकते हैं जो तस्वीरों में नहीं आए, जो दूर से बैठ करके इस पूरी घटना को बैकअप प्लान के तौर पर इस्तेमाल किया गया। बहरहाल अभी तक 14 लोगों को हिरासत में लेकर के पूछताछ की जा रही है। मैं समय पर धूमनगढ़ थाने के बाहर ही खड़ा हूं। देखिए, पुलिस अधिकारियों का जमावड़ा लगा हुआ है, पुलिस फोर्स मौजूद है, अंदर खुद जो जेसीपी हैं आकाश कोलहरी वो मौजूद है, पूरी टीम मौजूद है। 10 टीमें प्रयागराज पुलिस की लगाई गई हैं। जो रमित शर्मा है प्रयागराज के पुलिस कमिश्नर, उनका कहना है कि इन अपराधियों की धरपकड़ की जा रही है और ऐसी नजीर पेश करने वाली कार्रवाई की जाएगी जो प्रयागराज के माफिया एक सबक
हो सकता है कि आसपास ही भी मौजूद हो, छुपे हो, या हो सकता है कि राज्य भी बदल दिए गए हो, भाग गए हो, लेकिन सब कुछ एक कैमरे में कैद है। कितने भी बचने की कोशिश कर लें संतोष, ये बच तो नहीं पाएंगे क्योंकि कानून का हाथ लंबा होता है और पुलिस चाह जाए तो ये सब कुछ कर सकते हैं। और निश्चित तौर पर योगी आदित्यनाथ ने पहले ऐलान कर दिया, विधानसभा में भी उन्होंने कहा कि अपराधियों को बख्शेंगे नहीं, वो कहीं भी होंगे उनको तलाश लिया जाएगा और मिट्टी में मिला दिया जाएगा। ये 3 तस्वीरें संतोष, लेकिन पुलिस की टीम अभी किस तरह से एक्टिव है और टोटल लोग इसमें जिनकी भूमिका आ रही है, आरोपी तो नजर आ रहे हैं 4-5 लोग, कितने लोगों की संख्या हो सकती है?
देखिए, इसमें अभी तक जो पुलिस के पास है कि पुलिस को अंदेशा है कि 5 लोग सीसीटीवी से जो सामने आ रहे हैं, जिनको कि सामने आई है, लेकिन पुलिस को अंदेशा है कि इसमें 4-5 लोग और हो सकते हैं। 9 शूटरों के शामिल होने की आशंका है। देखिए, एक जो सीसीटीवी है वो बहुत साफ है, जिसमें दिख रहा है कि एक व्यक्ति उस गली का सीसीटीवी है जो इलेक्ट्रिकल्स की दुकान है। उस इलेक्ट्रिकल्स की दुकान में उमेश पाल के पहुंचने से पहले वो खरीदार ग्राहक बन करके वहां पे खड़ा हुआ है। वो खड़ा रह करके कुछ सामान खरीदता है और जैसे ही उमेश पाल की गाड़ी उस सीसीटीवी में भी दिख रही है कि वो उनकी गाड़ी आती है, ये व्यक्ति जो ग्राहक बन के खड़ा था, ये अपने कमर में लगाए हुए तमंचे से फायरिंग शुरू कर देता दुकान के बाहर निकलते ही। और उसके बाद
संतोष, एक और सवाल उठ रहा है इसके साथ, जब ये क्रेटा कार रुकती है, क्या इसको पहले से बंदूक की नोक पर रुकवाया जाता है इस गाड़ी को, या फिर इत्तेफाक से, संयोग से इन लोगों को वहीं रुकना था? क्योंकि आप देख सकते हैं कि वहां पर बमबाजी हो रही है, फायरिंग हो रही है और आप जिक्र कर रहे हैं कि दुकानदार भी कहीं ना कहीं वहां से गोली फायरिंग हो रही है जब शटर नीचे गिराया जाता है। तो किस तरह से जानकारी मिल रही है? कार को रुकवाया गया गन पॉइंट पर या फिर रुकी कार और उस पर गोलियां बरसा दी गई? नोक पर रुकवाया जाता है इस गाड़ी को या फिर
देखिए, जहां पर ये कार रुकी है उमेश पाल का घर है। उमेश पाल का घर की गली का ये सामना है जहां से ये कार रुकी। वो कल प्रयागराज कोर्ट से अपने जो 2006 में उन्होंने अतीक अहमद के ऊपर जो अपहरण का मुकदमा दर्ज कराया था, उस केस की पैरवी करके कोर्ट से लौटे थे करीब 4 बजे। 4:30 बजे यहाँ स्पॉट पे पहुंचते हैं और वहां पर गाड़ी खड़ी करते, क्योंकि बहुत तंग गली है, हम खुद गए थे। तो वहां पर 2 आदमी मुश्किल अगर निकलेंगे तो उनके कंधे टकराएंगे, इतनी तंग गली है। तो कार को बाहर रोक करके उमेश पाल अपने घर की तरफ जाते। ये इनको पता था कि उमेश पाल के घर की तरफ जाने के लिए कोई दूसरा रास्ता नहीं है। ये इनको पता था कि उमेश पाल अगर आएंगे घर तो आना ही है, तो घर जब भी आएंगे तो इसी गली से आएंगे, लिहाजा पहले से घात लगा करके बैठे थे। जो एक शूटर टोपी में नजर आ रहा है ग्राहक बन करके, वो पहले से इंतजार कर रहा है। लेकिन एक संभावना से इनकार नहीं किया जा सकता कि शूटर हो सकता है इनका पहले से पीछा कर रहा हूं, कचहरी से पीछा कर रहा हूं, कचहरी से पीछा करते हो, क्योंकि जो शूटर है वो पहले से एक जो लड़का दुकान में नजर आ रहा है वो पैदल है, बाइक से और कार से 2 गाड़ियों से भी शूटर आते हुए नजर आ रहे हैं। यानी कि बाकायदा रैकी की जा रही थी, बाकायदा पहले से इंतजार किया जा रहा था, बाकायदा पीछा किया गया और उसके बाद ताबड़तोड़ जो फायरिंग हुई, ताबड़तोड़ जो बमबाजी हुई, उसने उमेश पाल और उनके बहादुर गनर की जान ले ली। बहादुर गनर इसलिए कहूंगा कि सीसीटीवी में उसकी बहादुरी दिख रही है कि उसको गोली लगने के बाद भी वो भागता है, वो बचाने से भी शूटर आते हुए नजर आ रहे हैं। यानी कि बाकायदा रैकी की जा रही थी, बाकायदा पहले से इंतजार किया जा रहा था, बाकायदा पीछा किया गया और उसके बाद ताबड़तोड़ जो फायरिंग हुई, ताबड़तोड़ जो बमबाजी हुई, उसने उमेश पाल और उनके बहादुर गनर की जान ले ली। बहादुर गनर इसलिए कहूंगा कि सीसीटीवी में उसकी बहादुरी दिख रही है कि उसको गोली लगने के बाद भी वो भागता है, वो
बचाने के तहत इस घटनाक्रम को अंजाम दिया गया, हत्याकांड को अंजाम दिया गया। सीसीटीवी 1, 2, 3, 4, 5 बीच में जो तस्वीर देख रहे हैं, ये देखिए कार से नीचे शख्स उतरता है, उस पर ताबड़तोड़ गोलियां बरसा दी जाती हैं। और इसको लेकर पुलिस कमिश्नर क्या कह रहे हैं आपको सुनाते हैं।
दिनांक 24 फरवरी 2023 को जनपद प्रयागराज के थाना नूनगंज क्षेत्र के जयंतीपुर में श्री उमेश पाल और उनके 2 सुरक्षा कर्मी के ऊपर जानलेवा हमला की घटना कायद की गई थी। इस घटना में श्री उमेश पाल एवं एक सुरक्षा कर्मी की दुखद मृत्यु हुई एवं एक सुरक्षा कर्मी का इलाज चल रहा है, जिनकी कंडीशन अभी क्रिटिकल है। इस घटना के संबंध में 24/25 की रात्रि और 25 तारीख की सुबह श्री उमेश पाल इस घटना की पत्नी के द्वारा मुकदमा पंजीकृत कराया गया। धारा 147, 148, 149, 302, 307, 506, 34 भादवी विस्फोटक पदार्थ अधिनियम की धारा 3 एवं 7 CLA एक्ट के अंतर्गत इस मुकदमे में माफिया अतीक अहमद की पत्नी के
महागठबंधन की रैली इस वक्त चल रही है और लालू यादव वीडियो कॉन्फ्रेंसिंग के जरिए अपनी बात को रख रहे हैं।
विस्फोटक पदार्थ इस
आप लोगों को मालूम होगा कि आपको याद होगा कि पूर्णिया के मैदान से संघात होने के लिए आप हम इकट्ठे हुए हैं। बिहार में आज से रथ को बिहार वासी को बिहार जब प्रबंध होता है तब तक देश के ऊपर उसका असर होता है। बिहार के प्रवट हुए देश में हवा लगता है। इसमें भाजपा निर्वाचित है गुरु गोरखनाथ की पार्टी उसमें लिखा दो खतरनाक बात लिखा है कि उनके जहन है उनके खून है। उन्होंने लिखा है कि काशी विश्वनाथ मंदिर में अगर कोई दलित पहुंच जाए पूजा करने के लिए तो उसको मार के मिट्टी से मार करके उसको बांध और रिजर्वेशन को समाप्त करना चाहिए और रिजर्वेशन को बदलाव करना चाहिए। रिजर्वेशन की जरूरत नहीं है। ये है असली रूप आरएसएस का और भाजपा जिसे करते हैं। आप सबको याद होगा हाँ और 21 हो गए और कोई भी धर्म में नहीं रहे। गठबंधन विचारधारा का विचारधारा का है और हम हमेशा साथ रहने का देश और लोकतंत्र बचेगा तभी हम लोग राजनीति करेंगे। 2024 में से 25 के रिकॉर्ड तोड़ देना है। रिकॉर्ड तोड़ देना है जो चुनाव आने वाला है और बिल्कुल 2015 में जैसा रिकॉर्ड बना के उससे भी मजबूत बनाना है 2024 में। मुझे बहुत अफसोस हो रहा है कि मैं पूर्णिया के मैदान में उपस्थित नहीं हो सका क्योंकि इलाज करके और ये बोलने का ये जो ताकत मैं महसूस कर रहा हूँ कि हमारी बेटी बोलने सारी ने अच्छा नहीं दिया हम उस बेटी को इस अवसर पर बहुत बहुत धन्यवाद। हम उस बेटी को इस अवसर पर बहुत बहुत धन्यवाद देते हैं और उसके कर्जा को लौटा नहीं सकते हैं। आप सब लोगों को मैं बहुत बहुत धन्यवाद। एक रहिए, एकजुट रहिए और कोई भी आपको तोड़ नहीं सकता है जब तक हम लोग एक हैं। हमको देश बचाना है, बाबा साहब अम्बेडकर के संविधान को बचाना है, बिहार को आगे बढ़ाना है, देश को आगे बढ़ाना है, माइनॉरिटीज की रक्षा करना है। माइनॉरिटी हम सब लोग बोलते हैं हिंदू हिंदू हिंदू, अरे हिंदू जो है हम लोग हिंदू हैं, लेकिन माइनॉरिटीज
का क्या अपराध है कि तुम अलग करना चाहते हो, अलग करने का कोशिश कर रहे हो, टुकड़ा टुकड़ा करना चाहते, कभी भी हम सफल होने नहीं देंगे, किसी भी कीमत पर होने नहीं देंगे। और अब समय आ गया है नरेंद्र मोदी की सरकार को जाने का, विदाई होने का। ये पक्का है, ये बिहार का ये आह्वान है, ये महागठबंधन का ऐलान है। और ये संकल्प लेकर के आप सभी वहाँ से जाइए, पूर्णिया से निकलिए और हम पूर्णिया के इलाका जो सीमांचल का जो इलाका है, हमारा मोस्ट सेकुलर इलाका है, इसको किसी भी कीमत पर भिन्न भिन्न रूप में लोग आएगा, आपको बहकाएगा और उसको पहचानना है और एकजुट होना है और सेकुलर ताकतों को एकजुट होकर के पूरी देश की रक्षा में लग जाना है। और आगे 15 के चुनाव में पूरा 24 के चुनाव में पूरा मजबूती के साथ रिजल्ट देना है और बिहार देश को उस पर असर हो। माले के लेफ्ट के लोगों को अभी हम मुझसे मिले थे दिल्ली में, ये येचुरी साहब आके मिले थे, येचुरी जी मिले थे और उनसे भी हमारी काफ़ी विस्तार से बात हुई। मैं बात करते रहता हूँ, लोग मिलते रहते हैं। और अब आपको याद करा देना मैं चाहता हूँ कि ये जो राशन कि 5 किलो होता 10 किलो हम राशन दे रहे हैं, राशन दे के हम वोट मांग रहे हैं। याद होगा 1910 में ही सुप्रीम कोर्ट ने मजबूती के साथ, सुप्रीम कोर्ट का ये फैसला है, सुप्रीम कोर्ट का ये फैसला है राशन देने का, वितरण करने का, कि राशन जब सड़ रहा है तो राशन सड़ रहा था, गरीबों को बांटो। ये मजबूती से उसका ऑर्डर था सुप्रीम कोर्ट का। और ये बोलते हैं कि हम राशन दे रहे हैं, लगता है कि पूरा ये हल चला करके ला रहे हैं, पॉकेट से अपने ला रहे हैं, अपने घर से ला रहे हैं और वोट मांगते हैं। तो हमको पूरा मजबूती के साथ देश को बचाना है। सभी लोगों को मैं धन्यवाद देता हूँ और प्रणाम करता हूँ, आदाब करता हूँ, सलाम करता हूँ और सभी नेताओं को पूरे एक साथ विश्वास करके रहने की जरूरत है। सभी लोगों को नमस्कार। सभी पार्टी के महागठबंधन जिंदाबाद जिंदाबाद, देश को बचाना है।
तो महागठबंधन की रैली में लालू यादव अपनी बात को रखते हुए वीडियो कॉन्फ्रेंसिंग के जरिए जुटे थे और उनका कहना है कि 2024 में भारतीय जनता पार्टी का सफाया कर देंगे। रहेगी हर बड़ी खबर पर नजर, हर अपडेट पर नजर। छोटा सा ब्रेक ले रहे हैं, देखते रहें आज तक, लौट रहे हैं।
सभी लोगों को नमस्कार। सभी पार्टी के महागठबंधन की रैली में लालू यादव अपनी बात को रखते हुए वीडियो कॉन्फ्रेंसिंग के जरिए
दिल्ली और कोलकाता के भव्य कार्यक्रम के बाद अब साहित्य आज तक आ रहा है लखनऊ में बिस्मिल की महफिल का फ्री लाइव परफॉर्मेंस।
जो हल्का हल्का सुरूर है ये तेरी नजर का कसूर है कि शराब पीना सिखा दिया। ये जो हल्का हल्का सुरूर है साहित्य
अब साहित्य आज तक आ रहा है लखनऊ में बिस्मिल की महफिल का फ्री लाइव परफॉर्मेंस। फ्री एंट्री के लिए अभी रजिस्टर करें www.aajtak.in/साहित्य पर या फिर मिस्ड कॉल दीजिए 9310330033 पर।
मैं जैसे आपको बताया था, मेरी 16 फिल्में 17 फिल्में नहीं चल रही थी। हर आदमी, हमारे देश के कई लोग यहाँ वहाँ जाते हैं काम करने, कोई दुबई चला गया, कोई ऑस्ट्रेलिया चला जाता है, कोई न्यूजीलैंड। ये तो नहीं कह सकते नहीं गए, सभी गए हुए हैं। मैंने भी सोचा भाई मेरी फिल्में नहीं चल रही तो आदमी को काम तो करना पड़ेगा। मैं काम करने, मेरा एक दोस्त था जो कनाडा में रहता था, उसने बोला यहाँ के, मैंने अप्लाई किया, ये मिल गया, फिर मैंने वहाँ काम करना शुरू किया। मेरी बस 2 फिल्में रह गई थी रिलीज में, कोई ऑस्ट्रेलिया चला जाता। वो इत्तेफाकी बात है सुधीर जी, वो तो नहीं कह सकते नहीं गए, वो दोनों फिल्में अच्छी सुपरहिट चली गई। मैंने भी सोचा भाई मेरी अब मैं रुक गया, आदमी को काम तो करना। फिर मेरे दोस्त ने बोला तूने नहीं चल रही है वापस जा कर काम। फिर उसके बाद 2-4 और फिल्में मिल गई, फिर उसके बाद और फिर और चलता गया काम। अब फिर वो मैं भूल गया कि मेरे पास पासपोर्ट था, पासपोर्ट है वो इत्तेफाकी बात था। ये मैंने नहीं कभी सोचा कि मैं इसको पासपोर्ट को चेंज करूं, लेकिन हाँ अभी मैंने अप्लाई किया हुआ है पासपोर्ट में चेंज कर काम। फिर उसके बाद 2-4 और फिल्में मिल गई, फिर उसके बाद और फिर और चलता गया काम चलता गया। और फिर वो मैं भूल गया कि मेरे पास पासपोर्ट था, पासपोर्ट है वो इत्तेफाकी बात
లో కీలకమైన అంశాలు వెలుగులోకి వస్తున్నాయి. నిందితుడు హరిహర కృష్ణపై పలు సెక్షన్ల కింద కేసులు నమోదయ్యాయి. సెక్షన్స్ 302, 201 ఎస్సీ ఎస్టీ యాక్ట్ కింద కేసులు నమోదు చేసినట్టుగా తెలుస్తోంది. నవీన్ ని చంపినట్టుగా హరికృష్ణ ఒప్పుకున్నట్టుగా కూడా తెలుస్తోంది. 3 నెలల క్రిందటే నవీన్ హత్య కోసం అతను ప్లాన్ చేసినట్టుగా ఒప్పుకున్నాడు. ఈ నెల 17న నవీన్ ని బైక్ పై తీసుకువెళ్లి దారుణంగా హత్య చేశాడు. నవీన్ ని చంపి శరీరం నుంచి తలను వేరు చేశాడు హరిహర కృష్ణ. అబ్దుల్లాపూర్ మెట్లో ఫ్రెండ్ మర్డర్ కేసులో ఎన్నో ట్విస్టులు కనిపిస్తున్నాయి. ఒక యువతి కోసం ప్రేమించిన 2 యువకులు చాలా సార్లు కొట్టుకున్నారు. చివరికి చంపే వరకు వెళ్ళింది ఈ వ్యవహారం. అబ్దుల్లాపూర్ మెట్ నవీన్ హత్య కేసులో ట్విస్ట్ల మీద ట్విస్టులు. నల్లగొండలోని మహాత్మా గాంధీ యూనివర్సిటీలో ఇంజనీరింగ్ చదివే నవీన్ కి అరోరా ఇంజనీరింగ్ కాలేజ్ లో బీటెక్ చదివే హరికృష్ణ చాలా క్లోజ్ ఫ్రెండ్. హరికృష్ణ ఇష్టపడుతున్న అమ్మాయిని నవీన్ కూడా ఇష్టపడడం ఇక్కడ వివాదానికి కారణమైంది. ఆ విషయాన్ని జీర్ణించుకోలేకపోయిన హరిహర కృష్ణ పార్టీ పేరుతో నవీన్ ని పిలిచాడు. అతనికి మద్యం తాగించాడు, అతను కూడా మద్యం తాగాడు. ఆపై కసి తీరా నవీన్ ని చంపేశాడు. నవీన్ తల ముండాన్ని వేరు చేయడమే కాదు, మర్మాంగాన్ని కూడా కత్తిరించాడు. చివరికి ఆ అమ్మాయిని ఇష్టపడింది ఈ గుండె కదా అనుకుంటూ అతని గుండెను కూడా కదిలించాడు. ఇక్కడ వివాదానికి కారణమైంది.
కానీ మా అబ్బాయి ఉన్నాడు కదా, అక్కడి నుంచి వచ్చిన తర్వాత వాళ్ళ శుక్రవారం నైట్ ఆ బాబు కలిసి వాళ్ళ ఇంటికి వెళ్ళారు. ఇంటికి పోయిన తర్వాత వాళ్ళ మెట్రో నుంచి వాళ్ళ అక్కడ కూడా తీసుకువచ్చి
देखिए कल को कोई फंसेगा तो साइनिंग अथॉरिटी सबसे पहले जाएगा।
హరిహర కృష్ణ నవీన్ ఇద్దరు పార్టీ ఉందని నవీన్కి తీసుకొని ఇక్కడ వచ్చారు.
అసలు నవీన్ ఇంట్లో నుంచి
अभी हम एक फाइल कर रहे हैं, अभी हम ड्राफ्ट ही कर रहे हैं।
నేను కాలేజ్ దగ్గర ఇక్కడ వచ్చినట్టు వచ్చిన తర్వాత ఇక్కడ పార్టీ చేసుకున్నాను. పార్టీ చేసుకొని
हाँ अभी भी है।